Yes.
To mention one civil revision extremely urgent, 21st of December order was passed. In respect of an HON'BLE property, construction is carried on over my share of property also. I have an undivided share. Without my consent, my lord, I got an injunction from the trial court, and trial court injunction continued on 21st of December. Appeal court has negated the injunction, and against which I have come up.
No, under compelling
I leave my lord to mention, my lord, a very, very urgent matter from the list of determination.
Day after.
My lord.
Please mention the matters of the other determination first, because
That is what I am mentioning, my
coming
lord.
down.
Of the list and
Yes.
determination, my lord, Justice Shompa Sarkar, it's item number 1709. My lord, it's a very, very urgent matter. I tell you, lordship, why. There is imminent threat of dispossession, my lord. Well, this matter cannot
Are
be.
you mentioning upon notice?
My lord, it's a no caveat matter, my lord. This is a no caveat matter.
I am mentioning upon lordship.
May I see?
Upon notice, my lord. Very urgent matter, it will become infructuous.
My lord, I have no one to give.
The caveat as a with notice.
Mine is no caveat matter, my lord.
I have
May I see?
Yes.
May I see?
with notice.
Give the number.
No,
With notice.
আমি এটা লিখে নম্বরটা লিখে দিই।
Lordship, no caveat matter.
Lordship, no caveat matter, Lordship, extreme urgency, Lordship. Section 24 application, Lordship.
It will be difficult for me to take up all these matters on a single day, so I have to spread it over in my list. Yes,
Lordship.
may I see?
Lordship.
And please mention the item numbers if it is running in the list.
Lord,
May I see?
One by one, please.
May-
One by one, please.
May I seek my lords? May I,
Item number,
My lord, I am seeking my lord's kind
What is your
indulgence.
urgency,
may I?
madam?
Yes, my lord.
What is your urgency?
Lordship,
One by one, please.
Lordship, learned the next date is fixed on 11th, Lordship, learned court below, Lordship, and this is a section 24 application for matter, Lordship.
Give the number.
May I seek my lord's
Lordship,
kind?
kindly take it up tomorrow, Lordship. Next date is fixed, Lordship.
May I seek my lord's kind indulgence to mention one new motion? New motion, no caveat matter, my lord. My lord, I am the decree holder in this proceeding. My lord, on the last occasion, my application under section 33 of the Indian Stamp Act, read with section 49 of the Indian Stamp Act, was rejected. But what happened in course of the trial? Judgment debtor had tendered certain documents being agreement for assignment, being agreement for lease for 99 years, all unstamped, all unregistered. My lord, all those documents, my lord, were allowed to be exhibited by an unreasonable, my lord, order. Now, next date of the proceeding is fixed on 28th of January for final argument. My lord, if this matter is not taken up, my lord, it will become infructuous, my lord. There's grave urgency.
Number, let me see.
My lord.
Lordship, may I be permitted to,
About 25, 30 mention.
May I hand over the slip, man?
Lordship, may I be permitted to mention one?
Please wait for group one mention. Do not mention group one matters now. Please wait. I'm taking up the list of Justice Sarkar.
Lordship, with regard to
One?
Justice Sarkar, my
Group one, please wait. Please wait.
Lordship, with regard to the determination relating to Justice Sarkar, my lord, I am mentioning one matter. This is a matrimonial suit. The husband has been directed to pay rupees 10,000. There has been no reason given, and the husband is an unemployed youth, my lord. That has been also stated in the affidavit. In spite of that, 10,000 rupees per month has been directed as alimony, and thereafter 20,000 as litigation cost.
I will direct depositing the amount before I take up the matter, sir. Let me tell you.
Lordship, only for the
Depositing
adjudication.
amount, matrimonial cases, you have to deposit and then come before this court at least.
Your lordship kindly takes it up, let it come up in the list, my lord. Thereafter, whatever your lordship
Give the number.
directs.
Give the number.
Lordship, no caveat. And
Give the number.
Section
And that-
with regard to Justice Sarkar, Justice Sarkar is section.
I think I've crossed 50. By the time we take up the matter, Justice Sarkar will be back.
your lordship, one
I
other
have
matter.
a 2.5-year-old kid have to travel to Shiliguri on each day.
The next is figure
24, section 24.
Yes, one, any day, well, before 18th of January. 18th.
Give the number, give the number.
Your Lordship, may I be permitted to mention another matter, my lord? This is relating to substitution. I have filed the substitution application within time. My father expired. But the learned trial judge has taken a different date, has taken note of a different date and said that the suit has already abated. It was filed within 30 days.
Give the number.
Your Lordship, extremely
No,
great.
madam, may I be permitted to mention one matter, no caveat, new motion.
My lord, same thing.
24, my lord. Give the number.
Madam,
You have not served. Section 24?
Serving the notice.
Serve and come back. Otherwise, it will not be listed. Otherwise, it will not be listed.
Urgent matter of my son has to be admitted, in spite of
Notice আছে?
maintenance order being made by the court below,
Are you mentioning upon notice?
yes, my lord, I have given it.
Lordship, may I be permitted to mention two matters for the purpose of inclusion under the heading of contested application,
What
Lordship.
is your urgency?
Lordship, urgency is that, Lordship, in the month of, at the end of the January, the date is fixed for argument, Lordship. If, Lordship, argument will be completed,
This is the
then,
other benches matter.
Lordship, the matter
By
is,
the end of January, the bench will be back, sir. Please do not mention.
Lordship, 22nd January, Lordship.
Bench will be back before that.
22nd January, Lordship.
Yes. No difficulty. এই fan টা বন্ধ করতে হবে।
Actually, 22nd January, the argument will be completed, Lordship.
Let
Lordship,
the-
kindly
let
allow.
the regular, no, no. Let the regular court come. Yes.
But the petitioners have already come an option sale from the bank, Your Lordship. Has been more than 1 year, Your Lordship, please. I've noticed the other side, Your Lordship.
You can give the numbers, but I don't think I can take up all these matters in these few days.
May I have a Lordship kindly,
Extension of interim order, madam. Extension of interim.
This bench,
No, my lord, the other bench.
give the
may
number.
I have a Lordship kindly to mention one matter. I have been disqualified from my tenanted shop by an order dated
What is the need of?
7th September 2023. Now, the fact is, Your Lordship, that there is another suit pending where I have already have an injunction order. But suppressing that fact in another suit, they have said that I'm the tenant and they have dispossessed me. The construction have started and my tenanted shop have been ruined. Kindly take up this matter, Your Lordship.
Give the numbers, but I really.
My lord, may I have my lord's kind leave, my lord? This is a very urgent matter which we wish to move today at 2 p.m., my lord.
What is
The
the
reason, the urgency is that the matter is fixed before the Honorable NCLT today itself. The Honorable NCLT has passed an order whereby they have stated that they will accept my reply only upon a payment of cost of rupees 50,000. My lord is very well aware that cost of 50,000 is not permissible either in CPC or in the NCLT rules. The difficulty is the matter is fixed today. So if your lordship may, it's a very short matter, no caveat matter, my lord. If your lordship takes up, no, it will not take, I just need to show the provisions. It will not take more than 2 minutes also.
This matter, I don't think I can hear it without issuance of notice to the other side.
Very well, my lord, at least let me, my lord, takes it up at
File,
2 p.m.
please file and
Otherwise,
give the
my,
number.
yes, otherwise my entire application becomes infructuous, the matter is fixed today.
You can always mention that it is fixed here today. They'll
My lord,
consider.
just give me a short direction to serve notice. I'll serve notice and
Then come back. Give the
At 2
number
p.m.?
and consider. No, not at 2 p.m. tomorrow.
My lord, may I mention a matter, my lord?
AC
Now, my lord, group A, my lord, maybe.
My lord,
May I be permitted to mention this matter, Lordship? This is the application under section 24 of CPC and urgency is,
Mentioning upon notice?
yes,
my lord, may I mention a matter?
Lordship, kindly.
Suit was fixed for ex parte hearing, my lord. Without vacating the order, the written statement was accepted. It was fixed on first week of February, my lord.
This is not urgent at all. Mention only urgent matters because I will not be able to take up all these matters, isn't it? You must understand.
Lordship,
Mention extremely urgent matters because otherwise they cannot be taken.
Lordship, I will be highly obliged if you
What
could
happens is
kindly.
urgent matters will suffer because I cannot take up all of them.
Well, may I be permitted to mention a matter? It is running in the list of Honorable Justice Shampa Sarkar as item number 1573. In the learned court below, the date has been fixed on 11/1/2024 and suit is of 2005.
It is fixed for what?
It is fixed for hearing of the, we have filed a section 151 application under CPC. The court observed that you make a clarification, which is the correct forum to approach. No caveat matter. Kindly direct me to.
Understand. What is your urgency?
The date is fixed on
What, the date is fixed for what? Hearing of your 151 application.
151 application has been heard, but the court directed for a clarification.
So what is your urgency? Why are you before this court? There's no urgency at all. Let the court-
Kindly direct me to serve and come.
No urgency, sir. Please do not encumber my list like this. Please wait for the regular bench.
May I be permitted to mention one matter?
Yes? Give the number.
Lordship, kindly appreciate this matter. It is a very urgent matter, Lordship. 2nd February date is fixed for third hearing before the court below.
The regular bench will be back before that.
Lordship,
Your Ladyship may be permitted to mention, Your Ladyship,
One matter.
Yes?
Group A, one matter.
Give
Your Ladyship may be permitted to mention,
notice, upon notice.
Your,
My lord, may I be permitted to mention? My lord, urgencies. One is a section 24 application and both are from Justice Sarkar's list.
Are you mentioning upon notice?
My lord, these are under new motion and no caveat. And my lord, the urgency is that one of these, the section 24 matter is listed before the learned trial court day after tomorrow. And as there is a there is a last chance for filing written objection, and the wife cannot. She is a resident here. She cannot go to Malda to file a written objection. She has a minor daughter. And my lord, the other application is it's an application against it's a petition against an interlocutory order passed by the learned trial judge in a visitation matter where the visitation has been granted to the father, which was continuing, but it's an unsupervised visitation. Earlier there was a supervised visitation.
No urgency, madam. Please mention before the regular bench. No urgency.
Your Ladyship may be permitted to mention, Your Ladyship.
That child is deeply traumatized, and there are psychologist reports, and we have already made a prayer.
You can wait till the 22nd, madam. Please do not. Please do not.
May I be permitted to?
One matter.
One matter, my lord, inclusion in the list, my lord.
Upon notice?
Yes, also, my lord.
Your Ladyship may be
May I be
permitted to
permitted to
mention
take a leave to?
two applications, Your Ladyship.
I have taken out an application of essential repairs, madam. It is pending from October, madam. I want to, madam, the window panes have been broken, madam.
Your Ladyship, two applications of Justice Sarkar's determination, no caveat. This is my civil revision against two orders passed by the Learned Arbitral Tribunal. The next date of hearing is the 16th of January. There is a jurisdictional issue that is involved. I was only seeking your Ladyship's leave to file without certified copy of the order.
No,
And
not possible.
Your
Please file
Ladyship,
and
I
come.
would not get the certified copy because it's an arbitration order passed by the Learned Tribunal.
January is the date you said. We are only on
Yes.
8th today.
So may it be
please
taken
try
up
and get
any
your
day
copy.
before the 16th.
No.
Your Ladyship,
Please
I will
file
not be
and
able to
come.
obtain a certified copy.
No, is, granted.
Your Ladyship, I will not be able to obtain a certified copy
Have
because
you
this is
tried?
past.
Have you applied?
Yes, Your Ladyship,
Show me your application when you apply for it.
I shall come back to the app.
No, no.
Lordship, may I
Very
be
well,
permitted?
Your
Lordship, may I be permitted to take leave for the purpose of filing this application? Lordship, kindly take this matter at a 2 p.m. Lordship. Lordship, this is extreme urgent, and I have taken the report from e-court service. The next date is Lordship 18/1/2024. Lordship. Lordship, kindly
What is
take
the
this
matter about?
Lordship, actually, the matter was filed in the learned court below under Guardian and Wards Act for the purpose of custody of the minor son. Lordship.
Yes.
Lordship, kindly take this
What
matter.
is your urgency?
Lordship, the urgency is that Lordship on 18/1/2024 is a fixed for argument. Lordship.
We are on 8th today. You're asking for,
18/1/2024.
you are asking for leave to file.
Lordship.
File and come back. 18, today is 8th. You have 10 more days in between.
My lord, may I?
Lordship,
18
10
one
more.
is the next date
yes,
you
Lord,
say.
10
So
more days.
please file and come back.
Lordship,
My lord,
kindly.
my lord, may I be permitted to mention one matter?
Lordship, if I will file, Lordship, then the next date will be given of 22nd, Lordship, 22nd January, Lordship.
The
If I
revision,
normally file,
the revision has been filed.
no, with your Lordship's leave, I will file this revision, Lordship.
File and come back. No
Then,
need
Lordship,
My
then
lord,
the
my lord,
matter
may I
will be
be-
fixed on 22nd,
My lord,
Lordship.
may I seek my lord's kind indulgence? May I seek my lord's? My lord, may I seek?
My lord, may I be permitted to mention one matter? My lord, a title suit is pending against me since 2015, my lord, against me and one of the opposite parties, my lord. My lord, thereafter, my lord, the next date is on 18th April 2024. My lord, I am praying for expeditious, my lord, kindly, my lord. The matter is in Justice Sarkar's list, my lord.
Mentioning upon notice.
My lord, this is a CO, my lord. It needs to be admitted first. This is the reason I could not.
Give the number.
My lord, may I seek my lord's kind indulgence to mention?
My lord, I'm being late.
My lord, group one application, my lord.
My lord, may I seek my lord's kind
I'll
indulgence?
take up 10 matters each day of the other list. So now it is your, because I've already taken up more than 50 matters here, I think. So I really don't know how much of relief I can grant. If this is the level of mentioning, I really cannot help any one of you.
My lord, group one, my lord, group one, my lord.
The matter has been fixed on 19th. If it is after 22nd, I would not have mentioned.
What is your, what is the matter about?
Suit my order 39/7 has been rejected.
Yes.
Challenging that, I preferred a revision and application before this honorable court. But in spite of that, my lord, without hearing me, a date has been fixed for evidence. Without disclosing
Evidence will continue, so there is no urgency at all. Even if evidence starts, you are aware that nothing will happen to your application.
my application before your lordship will.
No, not at all. Not at all. It doesn't become infructuous, sir. You are aware of the CTC.
My
Even
lord,
if it starts, it
my
doesn't.
lord, may I seek my lord's kind indulgence?
That's the knowledge that I have about.
My lord, may I seek my lord's?
No urgency.
May I
The
seek-
argument is, my lord, is fixed on 15th, my lord. In a probate proceedings, my lord, we have filed an application, my lord, for appointment of an handwriting expert, my lord, that has been turned down. Now, my lord, the 15th, my lord, is the date, my lord, for argument. My lord, if your lordship, my lord, kindly takes up the matter any day, my lord, subject to your lordship's convenience prior to 15th, my lord.
15th, the argument is going to start, sir. So there's no urgency.
My lord, there will be 2 dates, my lord, I tell your lordship, my lord, prior to 22nd, the learned court below is proceeding with hot haste, my lord.
Please wait till the 15th, see what happens on the 15th and then come back.
My lord, may I seek my lord's kind indulgence, my lord, to mention one matter, my lord?
Upon notice?
My lord, may I have your one application?
Upon notice?
I have your
May I
lordship
seek-
leave to move an urgent unlisted motion. This is group one matter. Prospecting lease cum license, my lord, that of the owner's land. I applied for that. Report of the DLRO is, everything is okay for me, but DLRO on a, my lord, haste manner without going into the plot survey, my lord, rejected my claim on the basis of DLRO report rejected by the MDTCL. My lord, now the DLRO has issued notice that my part of my land is Sikasti, it will be taken over by the state. My lord, unless this is protected by your lordship, my lord.
File and give the number, I'll consider.
My lord, extensa from India. Extensa from interim.
Group one?
Number. No, my lord. No, sir.
Non-prosecution.
Extension.
My lord, may I seek my lord's kind indulgence, my lord?
Next 2 years, they have not giving him.
It's a group one matter.
One matter.
Are you mentioning upon notice? Give the number. Give the number.
Lordship, maybe. Blood one leave to move blood without certified copy and blood without certified copy blood and the matter is blood to release the matter tomorrow blood because the blood.
What is your urgency? What is
Yeah,
the matter about?
Blood I am the defendant in a suit for eviction. But
Yes.
there is a direction from this honorable court decide the suit as expeditiously as possible. Lord, I paid for 1 day time to cross-examine the PW1. Lord, my right to cross-examination has been closed by the first order and the second order. My right to make argument that has also been closed. Two order impute challenge before your lordship. Lord.
Give the number.
Lord, 19th is the date fixed.
Give the number.
Lordship,
I'm
may
not
be permitted to mention.
required otherwise in absence.
19th is, we still have 11 days more, sir. File and come.
No, Lord, without
Leave is not, leave will not be granted.
Lord,
Please file and come.
without certified copy, I am asking.
No.
Lord,
When was the order passed?
Lord, on last order 4th January 2024.
Have you applied for certified copy?
I applied for that has not been granted, Lord.
Please wait for some more time. Without certified copy?
My lord, may I seek my
May I
lord's
be
kind
permitted
indulgence,
to
my lord?
mention, my lord?
My lord, may I seek my lord's kind indulgence to mention?
Group one matter.
My lord,
Are you
my
mentioning
lord, may
upon
I seek
notice?
my lord's kind indulgence to
You're
mention
mentioning
one?
upon notice?
Lordship, may be permitted
My
to
lordship,
mention
may
one
I-
urgent matter, very, very urgent matter. I am the tenant of a property, land acquired by the NH authority. No notice has been served upon me, even if I intimated that I am the interested person. And the bulldozer is standing upon my property.
Upon notice?
Yes, Lordship, upon all them. Lordship, under urgent motion, Lordship. Tomorrow, Lordship.
My lord, may I be permitted to mention, my lord?
My lord,
Group one?
Mr.
Upon notice,
Group one, civil revision.
upon notice.
But I have given notice in
Deeply.
respect of that bit, well, once again I will give notice.
With my lord's kind leave, my lord.
Let me see.
My lord, may I seek my lord's kind indulgence to mention, my lord? My lord,
Give the number. Give the number.
My lord, it's a group one matter, my lord. Mr. Basu is reading me. He's, my lord, attempting to mention
my lord.
online. My lord, he's there on the screen.
my lord, may I seek my lord's kind indulgence to mention the group one matter, my lord? It was mentioned, my lord's view was that since, my lord, today is the date when the combined list would be published, my lord, your lordship directed my junior, my lord, to come on this day. My lord, urgency is this, my lord, National Highway, my lord, the authority, my lord, they are proceeding with the matter, my lord, with a hot haste, my lord. Now, my lord, we have also, my lord, recorded our objection with regard to the amount of compensation and the procedural aspect, my lord, in this matter. My lord, in a similar circumstance,
My lord, upon notice,
my
yes.
lord, yes. Notice, my lord, and not only that, my lord, your lordship was kind enough to dispose of other matters, my lord, who are similarly circumstanced, my lord. If your lordship, my lord, passes the same order, my lord, there is no question of subject to correction, my lord. Today, if your lordship takes out tomorrow, day after tomorrow,
Is
subject
it
to your
running in
lordship.
the list?
No, my lord.
No, this has not been included.
It's returnable
Let
to.
it be included. Let me see. Give the number. Give the number, please.
I'm extremely grateful, my lord.
Your lordship, group one.
This is a Are you mentioning upon notice? Give the number.
My lord, may I like to mention for inclusion?
Group one matter.
No, in the year of 2014, the land of the petitioner acquired and subsequently utilized by the government, but not yet disbursed the compensation.
It's a group one matter.
Group one land.
Are you mentioning upon notice? Give the number.
Your lordship, may I have your lordship? While the petition under 35 of the order was passed on 5th of January. She obtained the server copy of the order on the 6th month. Occupation which is directed to pay, which is the of the property, which is the cheaper property. So when the occupation has to be paid by 15th pilot, the entire period. So when
You still have some time, so please wait for the certified copy. No, wait, please wait for the certified. Take the collect.
Lord, may I have my lord's kind leave to mention one matter, Lord, determination of Justice Sarkar.
Yes.
Lord, this matter is very urgent, Lord, in absence of the bench. I moved the matter before Justice Basu. Lord, his lordship recorded the urgency and directed me to serve notice upon the other side. I have served. This matter, Lord, with the police help upon depositing of course, date was fixed for delivery of possession in execution case. They made an application for the executing court. Executing court, well, it is a contested matter. You have preferred an appeal to go before the appeal court for bringing stay order. Lord, appeal was dismissed. In the meantime, they again came against that order before this honorable court, and the Lordship, the Honorable Justice Sarkar directed that you move the appeal court. Rightly done. Appeal has been dismissed, suppress the said fact. Then, Lord, again, same stay application was moved before the learned trial court. He has granted stay. Everything has been frustrated, and Lord, the next day he speaks for police. Lordship kindly entertain the matter.
Lord, the one matter, Lord, the no caveat matter, Lord, the urgency is this suit for eviction. I am the defendant. Lord, I paid for some time to make the argument that by the order issued that was closed. Lord, I need some time to make the argument before the trial court in any date. Lord,
When is the next date?
Lord, 11th is the date fixed.
So the argument is going on.
At the stage of argument.
So what is your urgency?
But on 4th that I paid for the time to make the for my preparation to argue the matter.
That has been turned down.
Turned down.
The advocate has died.
And my previous advocate expired, Lord.
Give the number.
Your lordship.
Group one matter. This matter I had mentioned earlier before your lordship, considering the urgency, your lordship takes the matter as mentioned matter. But in the passage of time, the matter could not be taken up, your lordship.
You're mentioning upon notice? Give the number.
Your lordship, group one, I'm mentioning upon notice group one hearing matter for inclusion, your lordship.
Group one hearing that affidavits are complete?
Yes, your lordship.
Affidavits are complete?
Your lordship, we have submitted affidavit, but the state has not, considerable time has passed, but the state has not filed a
The
affidavit.
number, let me see. Hearing matter. Group one hearing matter. Affidavits are complete. Give the number.
My point of mention, my lord, upon notice, my lord. My lord, personal lordship reaction, my lord, demolition order has been passed, my lord, by the NH.
In spite of that, no demolition, you can place, my lord.
Upon notice?
Yes, my lord, upon notice, my lord.
My lord, the effect of that matter already noticed in code number 19 and.
But you to serve a further notice.
Again, my lord, kindly.
Lordship.
Notice service direction. Include करो ना.
I will submit.
Lordship, I went to the filing section for the purpose of a filing, but filing section said that before 22nd, if I want to place the matter before your Lordship, before 22nd, then your Lordship's leave is highly solicited, Lordship.
File and mention, I'll fix everything.
Because Lordship, if I file Lordship, then the date of 22nd will be given.
What is your urgency?
My urgency is that Lordship, on 8, I have taken the report from e-court service, 18 January 2024 is date fixed for argument. Lordship, if the matter, the argument of this matter will be completed, then the entire revisional application will become infructuous.
Argument completed in a day before the trial court, sir?
Lordship?
Is argument completed in a day before a trial court? It
Yes,
takes
Lordship,
some days for completion
because
of argument.
18/1/2024 is the second date for argument, Lordship.
Yes.
Then Lordship, kindly give me a leave to file, and Lordship kindly fix any date before 18 January, Lordship, before any date.
File and mention, I'll fix
Lordship,
any
if
date.
I will file, Lordship,
I
then the
know that
filings
they'll give you 22nd as the date. After that mention, I'll prepone the date.
after filing.
After filing, yes.
The three urgent matters related to the list of very urgent matters. Three matters, all of the matters are in the combined list. One is the execution is
What's
possible.
your urgency?
Urgency, my lord, my execution, my stay application in an execution case has been rejected on the ground that appeal has been preferred against the appeal court says that I have got no power to stay my own, to stay the execution case. Strange order. Another case, my lord, identity order was refused. Appeal preferred by I'm the defendant. Identity request, appeal preferred. Okay, but appellate court what has done, my lord, without service of notice, dispose of the main injunction matter, restraining me from entering to my own great field. Without service, that is not the law, my lord.
Are you mentioning up a notice?
My lord, no caveat, my lord.
No. Give the number, let me see.
And another thing, my lord, in a just photo in the trial court directed my client to deposit 2 lakhs rupees within 15 days. But that is not required to be registered. That was done long back.
Give the numbers, but I make it very clear. I will take up 10 matters each day.
Yes.
Because I have a long list. I cannot take up more than that each day. So I do not know where it will appear.
Well, any date, my lord, subject to a lawsuit.
From 3:30, I'll take up 10 matters of the other bench.
My lord, may I have lordship's kindly to mention, my lord, this is group 1 matter, matter of year the 2022, my lord, this is only for inclusion in the list, my lord. I have sub notice, yes, my lord.
Justice Sampasaka, my lord. Two matters, my lord, I'm mentioning, my lord, both are running in the list. My lord, the urgency in one of them is, my lord, in a suit where declaration of Barga is, my lord, involved. My lord knows, my lord, that will be decided by BLLRO, and my lord, this will come to the court. So, my lord, the learned trial court, in spite of the matter has been referred and pending before the BLLRO, my lord, was, my lord, proceeding with this suit. I filed an application that kindly keep it in abeyance and make a direction upon the BLLR to expedite it. But that was dismissed, and my lord, next date is fixed for my lord peremptory hearing.
So no urgency.
My lord,
Even if
once my lord peremptory hearing will be started, my lord,
what will happen?
without my declaration of Barga, which is pending, my lord knows in such nature of suits.
It can be dealt with by the regular bench.
My lord,
Peremptory hearing doesn't start and end in a
my lord,
day.
if my lord, may I say, my lord, if evidence will start, my lord.
How will you be prejudiced if evidence starts?
My lord, without my declaration, I am the plaintiff. Kindly consider, my lord.
You can come and decide.
My lord,
It is not that urgent that it has to be.
my lord, kindly consider that I am the plaintiff in the suit.
I understand.
On the
sir.
preemptory hearing date, my lord.
Whatever you submit. But even if the peremptory, if the evidence starts, you will
My lord,
not be.
there are, my lord,
prejudiced until it
judge.
ends.
My lord,
It's
there.
not that the suit is going to be disposed of.
My lord,
You have some time with you, so please come back.
my lord, there are judgments, my lord, which says that the court cannot proceed with the matter.
But the regular bench can come and deal with it. It's not that urgent that I have to deal with it.
In another matter, my lord, may.
Come back. Yes.
But there is another matter, my lord, may I try, my lord.
I will only deal with matters of extreme urgency.
Yes, my lord, may I say, my lord. Application for stay of the, my lord, the execution case was granted, my lord, at a occupational charges, my lord. At a much higher rate, my lord. 400 rupees has become, my lord, 6,000.
one team said, my lord, 50 square feet room. My lord, that is, my lord, I am running at risk, my lord, of my lord execution, and that too, my lord, in a proceeding under Order 9, Rule 13, which has been admitted.
The execution date has been fixed.
My lord,
Execution date has been fixed.
not the final one, but my lord, it has reached, my lord,
So
final.
you can wait till the regular bench
My lord,
comes.
my lord, only one thing, my lord, since this was made a precondition, my lord, and if I failed, my lord, the executing court will, my lord.
Wait for the next order of the court. Wait for the next order.
Also, may I permit to mention one motion matter for urgency. Urgency is the petitioners are the owner of the property from the predecessors. Defendant have no manner of right title interest taking forcible possession of the suit property which was acquired by GAIL for installation of pipelines. Plaintiffs are claiming unlawfully compensation against the suit property. London just passed the order, but on the basis of that order, plaintiff challenged the petitioner by filing the revision application before the honorable.
Plaintiff challenged
The revision application before this honorable court.
against which order? The order is in favor of the plaintiff.
No.
What is the order of the learned court, trial court?
Uh,
What is the order of the trial court that you are challenging? What is the order of the learned trial court that you are challenging?
Order I have not annexed to.
You said something just now. What is the order? Yes?
No, I have no. I have the order not annexed to with me.
Not
Also.
necessary. What is the order passed by the learned court?
I don't know the law, sir.
You cannot make your submission also on that. So please be prepared and come back. Get ready and come back.
Lordship has allowed me to mention this matter, but a notice was not tagged. Notice has been tagged.
Group 1.
No, Justice Sarkar's determination. One matter I have mentioned already.
What is your urgency?
Urgency is I am threatened to be interrupted from the common area in spite of order of injunction. And matter has been filed in the month of February 2023. Is not the opposite party is creating disturbance.
This doesn't mean that.
He has transferred the entire property to the co-sharer.
Yes, please wait till the regular bench comes.
Very
It's
urgent.
not that urgent.
Only one matter, very urgent.
Appear to be
In
very
the
urgent.
month of February 2023.
Yes,
it
so you
was
waited
filed.
since 23. Please wait for a few more days.
My lord, February 2023, matter is taken up for hearing for admission.
By the normal. Please come back. Please come back. You're asking for expeditious disposal.
No. Injunction order has been passed in favor of the petitioner. They preferred appeal before the miscellaneous appeal court, first appellate court. First appellate court modified the order of injunction, set aside the portion, whereby we are the owner of the property along with common passage. The opposite party transfer entire property to the co-sharer. Have no right to administer over the property, regularly creating disturbance. It has become impossible to enjoy the property. That is very urgent.
Give the number. Let me see how far I can deal with the matters.
I'm paying for only for inclusion of the list.
Of group 1 matter.
Malad.
Have you served the other side? You're mentioning
Only
upon
served, only
notice?
served.
You're mentioning upon notice?
No, I am not for upgradation, Malad. For inclusion, Lord.
Anything. If you mention, it has to be upon notice.
No, Malad.
Please serve notice.
For inclusion also.
Yes, of course.
May I permit
Any
it to
mention
mention?
should be upon notice.
Your Lordship, may I permit it to mention one matter? It is regarding the determination of Justice Sarkar. I have not mentioned this matter, Your Lordship. The next date it fixed in on 2 dates before the learned lower court. The fact is that my substitution application is held up before the learned lower court because the pendency of this application, which is pending before this honorable.
Substitution application is?
Pending is not taken up by the lower court as because the civil revision application is pending before this honorable court. There is application for substitution which is also pending before this honorable court. The learned lower court below is not taking up the substitution as the substitution which is also pending before this honorable court. Unless the substitution is not allowed by this honorable court, the learned court below is not willing to take up the
You're mentioning upon notice?
Yes, it is already given. I am also giving the unless
Give the number. Give the number.
Lordship may be permitted to mention one matter. Your Lordship, I'm mentioning for inclusion in the list. Your Lordship, the matter is about National Highway has acquired the petitioner's land. Your Lordship, subsequently, they have not given any compensation and steps are being taken to demolish the land.
You're mentioning upon notice?
Your Lordship, no.
Mention upon notice.
But I have given the notice.
Group one.
Group one.
My lord, may I be permitted to mention, my lord, the determination of Justice Sampa Sarkar. My lord, in this matter, my lord, no caveat is there. My lord, urgencies, my lord, there is every apprehension of disposition without due process of law. My lord, I have prayed for ad interim injunction, which was refused by the my lord learned district judge as well as the my lord learned trial court. So, my lord, there is grave urgency. I, my lord, mentioned earlier on before Justice Sarkar, my lord. The matter, my lord, appeared, but due to my illness, I could not, my lord. And my lord, another matter, my lord. That is also, my lord, now pending before Justice Sarkar, my lord. Here, my lord, the initially, my lord, ad interim order of injunction was passed by the learned trial court. Thereafter, my lord, the respondent, my lord, filed the order that rule 4 application. Though, my lord, the learned trial court held that there is prima facie case, but their application was allowed. My lord, we preferred appeal. My lord, the appellate court, my lord, affirmed the order of the learned trial court. So, my lord, construction is going on, encroaching my land. So there is grave urgency, lordship can
Give
appreciate.
the number, but by the time I take up these applications, Justice Sarkar will come back.
No, my lord,
Because more than 50 matters have been mentioned today. And I'll take up 10 matters each day, not more than that.
no, my lord.
Give the number.
Lordship, Lordship, may I permit to mention to list of Justice Sarkar, item number 1751. There is the revision against the order of dismissal. The application filed for restoration that has been dismissed by the learned tribunal is the application for motor accident claim case.
This can wait till Justice Sarkar comes back.
Lordship, I am only for direction to sub copy upon the respondent. Now, nothing I am
Not
paying
going
for.
to encumber the list further. Please wait till Justice Sarkar comes.
My lord,
It's
may
not that urgent, sir.
My lord, may I be permitted to mention this matter, my lord? This is also from the list of Justice Sarkar. My lord, this is an expeditious disposal matter, my lord. This matter was filed in 2012, my lord. 72 hearings took place, out of which 60 adjournments were allowed. Only 12 effective hearings actually happened in the trial court.
Don't you think this can wait till the regular bench comes back?
My lord,
There is no extreme urgency in this. Wait till the 22nd and then mention.
My lord, may I submit? I submitted my senior Mr. Ramesh Kumar Chaudhary. He expired on 28th December. Today is slab ceremony. So my item number, line number item 12 is today's schedule. Could you kindly adjourn it for 2 months? Because actually,
Let me call the list, sir. Let me call
my
the
lord,
list.
actually start ceremony. That's why I'm
Didi 12 টা নোট করুন তো adjourn
item 12. My
12 টা নোট রাখুন adjourn হবে আমাদের লিস্ট 12
I'm grateful, my lord. I have to attend. My lord. That's why.
Please call the days.
My lord, may I be permitted to mention a matter? My lord, I am the petitioner here and challenging the deed of convenience. So, my lord, the interim order has been rejected. However, there can be a third party right involved. Therefore, I am praying for an injunction again.
There can be a third party. When is the next date fixed before the court? Trial court?
My lord, this is a matter from Justice Sampa
I
Sarkar's list.
understand. When is the next date before the trial court?
My lord, the matter is in the list, item number 832.
Before that, it's pending before the trial court, the suit, isn't it?
Yes, my lord.
The suit is pending before the trial court.
Yes, my lord.
When is the next date before the trial court?
My lord.
The injunction has been refused by the trial court.
Yes,
You've
ma'am.
come up against that, isn't
Yes,
it?
madam.
When is the next date before the trial court? You're not aware.
No, ma'am.
Please come back later.
May I permitted to mention one more matter? The next date fixed on 11 January 2024. That is why the urgency came up. And the fact is that the London trial court has allowed in my shoot the third party has been added. And because of that, my shoot has been completely in peril. If the lordship kindly allows the
No urgency. No urgency.
My lord, may I mention the matter? My lord, is appearing in the monthly list of Justice Shampa Sarkar. Interim order has to be extended, my lord. May I give the slip, my
Are
lord?
you mentioning upon notice?
Yes, my lord.
Well. Yes, call the raised list, please. Didi, chronologically, year-wise, 10 matters every day from 3:30 p.m. কাল থেকে লিস্ট একটা লাইন অ্যাড করবেন the matters urgent matters from the list of justice bench number দেবেন shall be taken up from 3:30 p.m. each day 10টা করে ম্যাটার পাবেন year wise chronologically রাখবেন ওটা সেটা যেন ব্রেক না হয় না কেন year wise and 10 matters. Each day, 10 matters will be listed. Yes, call the days list, please.
Well, this is my affidavit of service. But upon notice, yesterday also, my lord, I mentioned the matter. My lord, my matter is this, my lord, that my lord, in the year 1986, the my lord, land was requisitioned on 20th of January under section 3(1). 1987, the position was taken over by my lord, by the government. Since 1987, that the government did not award the petitioner, father of the petitioner who died. In the meantime, the father of the petitioner made a read petition before this honorable court. Pursuant to the order of the honorable court, where the honorable court was pleased to direct the respondent authority to give the award within 12 weeks from the date of communication of the 1996, the payment of compensation was made. Amount, lordship, kindly have a look to page 5. Amount was 1,38,253.
I do not find anyone for the state today. What is
I have
wrong?
already served, again served, mentioned on Thursday, again served on
Mr.
Friday.
Kottawal? No one is there for the state today. May I request you to appear? Please serve him a copy of the writ petition so
My
that he
lord,
can appear in this matter.
Yes, here and now, let me finish the only consideration. Now, against the state award, that is 1,38,233. The petitioner's father made the proceeding was started before the LA tribe. Lordship, kindly have a look to the order. Order is page 19. The order is this, that the reference and the same be allowed on contest without any cost, the price of the land be enhanced to rupees 15,000 per kata. The petitioner to get 30% solitium over the market value as per provision of section 23(2) of LA Act and 9% interest of the enhanced amount for 1 year from the date of taking over possession. This is the order. Against the said order, state government preferred an appeal. When the appeal was preferred, that is, lordship, kindly have a look to page 22 in the year 2002. Since 2002, the appeal is pending. Here the state government is the appellant. I am for the respondent. In the meantime, the appeal was dismissed, again restored. During pendency of the said appeal in 2011, the father of the petitioner made a writ application before the honorable court praying for against the inaction of the respondent authority. 27 lakhs he has already received. What happened thereafter, the other co-sharers, who are page 28, the entire matter has been amicably settled in title execution case. But you kindly have a look to page 28. Fourth paragraph is this, on being asked, learned advocate for the decree holder submits before this court that for the present his client is ready and willing to accept 61,24,380 from the LA collector, Shuri Birbhum, Government of West Bengal without prejudice and without waiving his claim to Tunam such as such. My prayer is also same. Whatever government is ready to pay, we are ready to accept. I made a representation before the authority concerned, that is started from page 34 onwards. Page 34 on, let it be considered whatever government is willing to pay, we will accept that. Page 34, after giving an opportunity of hearing, we will appear before the authority concerned and they will decide whatever government will decide, we are ready to accept. Because in course of time, the original owner died due to COVID period in 2021.
The appeal is pending before which bench?
Appeal is pending, not in any bench, pending in department.
ডিপার্টমেন্টে অ্যাপিল
ডিপার্টমেন্টে অ্যাপিল পেন্ডিং হয়ে আছে, কোনো বেঞ্চে তো নেই, অ্যাপিয়ার করছে।
এলএ জাজের অর্ডার পড়ালেন তো।
হ্যাঁ, তারপরে অ্যাপিল করেছে স্টেট
It
গভর্নমেন্ট।
says that your representation says that it's pending before this court.
This court, that is page 22.
That is first appeal.
First appeal is pending before this
Whatever,
government.
may I, if আপনি যদি শেষ হয়েছে,
হ্যাঁ,
perhaps the better course of action would be going before the first appellate court.
That's why I'm asking this. That's the reason why I'm asking. Before the court where the appeal is pending, you have to make this prayer there, not before this court.
Your appeal is not listed, but it is in the department because the I am not the appellant
You
in
have
this matter.
please take necessary steps for listing of the appeal. Please mention before the first appellate court. Since the appeal is pending before this court, I don't think it will be proper on my part to dispose of the matter like this.
My Lord,
Because
can you pass the necessary order so that I can, my Lord, mention the
I
matter?
cannot pass any order in this matter. You have to withdraw. Or have to dismiss on this ground that it's pending before some other bench.
No, my Lord, may I make one prayer before your Lordship, my Lord? Only thing is this, my Lord, that your Lordship kindly direct the petitioner to take appropriate action before the appellate court. This much, my Lord, I can show the appellate bench.
I will record your submission.
My Lord.
I cannot give a direction.
My Lord, kindly record it. Yes.
Affidavit of service.
People to submit করিং এর কোনো 22 বছর হয়ে গেল
ওই ঘরে কি না না এই ডিসেম্বর এই ডিসেম্বর ঘরে কি বললেই হবে
পরিষ্কার
হ্যাঁ by the SDO you know yes I have the order
এখন পাকা নাম্বার পড়ে গেছে
ডিসেম্বরে
আপনি তুলে দিন মামাটাকে শেষ করে দিন
সেম ডে সেম ডে হলো why is it
It is submitted on behalf of the petitioner that
stay বলছি তাহলে স্টেটা দাও ওকে
an application submitted by the
by the consultant still shall take the same into consideration while the adjudications as directed above if necessary.
The section 8 application was by the predecessor. By the predecessor in interest of the petitioner. Under section 8 of the
Under section 8 of the Land Acquisition
48 Act
48 Act. Act 2 read with section 18 of Act 1.
of the West Bengal land within bracket requisition and acquisition bracket closed Act, comma 1948, read with section 18 of the Land Acquisition Act 1894 was
আমি কন্ট্রাক্টে তোমার সাথে আমি ভাবছি ওটা পৌঁছে গেল
disposed of
ডেডবডিকে নিয়ে আমি কি করব
by the learned land acquisition judge by an order
suppose that this proceeding secretary has experienced
passed on 12th June 2001 in LA case number 39 of 1997
if this has experienced this as within February 29 there will be
comma allowing the reference on contest. Stop. The state carried the said order in appeal.
I am not the state. আমার কাছে আছে I have another two down.
Which was dismissed for default and subsequently restored. Stop. The appeal is still pending before this court. Paragraph, learned counsel for the petitioner seeks to take necessary steps before the learned appellate before the appropriate bench dealing with the appeal.
One prayer. But prior to this, Lordship can consider, record this that I have paid before your Lordship for settle the matter out of court. Thereafter, I am seeking.
Very good. Learned counsel for the petitioner submits that the petitioner is ready and willing to accept the amount the state decides to pay as compensation and settle the issue with the state amicably out of court. তারপরে learned counsel কি বলেন তারপরে seeks to ওই যে পরের লাইনটা তারপরে take necessary steps before the কি বলবো appropriate bench dealing with the এই learned counsel for the petitioner seeks to ওটার পরে দিন appeal is still pending এর পরে আপনি যে লাইনটা বলেন it is submitted on তারপরে learned counsel seeks to take necessary steps. Paragraph, in view of the above, the writ petition being WPS such and such is disposed of. Paragraph, liberty is granted to the petitioner to take appropriate steps before the learned bench dealing with the issue, dealing with the appeal. Paragraph, there shall however be no orders to cause urgency required website.
Most probably there is a typographical mistake, Millard, in the Millard cost title, most probably name. That
Name of?
Name of Millard petitioner, only Guin, G-U-I-N. The pause list, it was U-N-I.
No, G-U-I-N.
My
No, no,
mistake,
petition
that
is
pause list
GUIN.
GUIN. Yes. Then it is okay. Grateful, my lord.
Next.
Affidavit of service, Millard, let it be
Take
kept.
it.
I am for the applicant lordship. On pursuant to your lordship direction, the exception has been filed, lordship. And already
Lord,
served a copy, lordship.
I have filed the compliant report, affidavit of compliance, my lord, wherefrom it appears that what is the my lord's order has been truly complied. My lord, kindly come to the my lord's order, page 27 of the contempt application, that is operating part.
This goes on.
What was the direction upon the district magistrate? Page 27, bottom portion.
Rehear the parties and pass a reasoned order.
Reasoned order.
Pass the demolition
Thereafter-
order, lordship.
thereafter,
Thereafter, lordship, HDO already taken the decisions
আরে আমাকে বলতে দে না মানে
and to
তুমি যেটা বলছো তোমার নিজেরটা বলো।
thereafter মানে kindly come to
remove the
compliance report,
encroachment law.
compliance report page 14. That is the ordering part of the SDO, district magistrate. আমাকে বলতে দে, তোরটা তুই বল। Page 14.
An inquiry was directed to be held. Has that been held? A fresh
My lord,
inquiry?
yes, fresh inquiry was made, lordship, and after that, the encroachment has been found, and on the basis of that fresh inquiry report, lordship, DM has passed the order to remove the encroachment, lordship. And already communicated to the SDO, lordship. SDO already also sent it to the officer in charge and the local authority.
So the order has
My
been
lord's order has been complied with.
Not that, the lordship, kindly see the SDO direction. Still not been.
My lord's
What's the order?
Order was to rehear the matter
to pass a
and
reasoned
decision
order.
to be
And pass a
communicated.
reasoned order.
That order
was
Pass the order, lordship, but not fully being complied, lordship.
Contempt is infractious, my lord.
Is passing. Please see the order under contempt.
Page 27.
To
Ordering-
rehear the parties and pass a reasoned order.
A reasoned order passed.
Upon affording opportunity of hearing.
Order
That
was
has been
but
passed.
not been removed, lordship.
There
Kindly
is
see the-
fresh cause of action.
Exception used by the applicant
Okay.
petitioner to
Which
the
cause?
compliant, to the
Follow na,
affidavit of
follow,
compliance
rescue order follow.
submitted on behalf of the state
এবার ওটা ছিল
respondents, on behalf of the alleged contempt
কন্টেন্ট
is taken on record. Affidavit of compliance, the compliance report.
পাবে না ও তাও কি 300 মিনিট তো দাদা
No, affidavit of compliance.
সেটা সবনি বললে
Paragraph, it appears that the order under contempt has been substantially complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of, there shall however be no orders to cost as in certificate of program.
ঠিক আছে
Substantially complied. Next.
আইটেম 2 কত ইয়েস
Okay. Contempt not please. Contempt not.
Actually, I'm for the applicant and private respondent are complied with their order.
Complied with their order? It is submitted on behalf of the applicant petitioner that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of, there shall however be no orders to cost as in certified website. Next.
আরে জানুয়ারি 2023 এর অর্ডার ঠিক আছে
Hey, please, your lordship, my lord. Very lordship, my lord had directed me to serve copies of the contempt petition on the alleged contemners.
Which is served?
My lord, we've served, my lord. The Gram Pradhan has refused it. The rest of them, my lord, have received it, so it's good service. My lord, the lordship is kind enough to take up, my lord, the original order, which is.
Give me a minute, please.
I'm sorry, my lord.
Who is the contempt?
My lord, the Gram Pradhan and my lord, the executive engineer. There are three alleged contemners.
Mr. Day was appearing in the original.
In the original writ petition, my lord. The block land and land reforms officer, which is the supervising authority, and my lord, the Gram Pradhan and the executive officers are the tendering authority. My lord, there is a tender, my lord, which is, my lord, the subject matter of challenge before your lordship, my lord, and your lordship was pleased to pass an order directing stay of the construction which was sought to be carried out in the
You've come
district.
up against that order. The writ petition is pending still.
The writ petition is pending, my lord. The next date perhaps is fixed on the 11th, my lord. Well, page number 24 is the initial order whereby your lordship, my lord, was pleased to grant stay of the construction which was sought to be raised, my lord. And that, my lord, has been extended from time to time and is still subsisting. Now, my lord, 17th May, since thereafter, my lord, constructions have been sought to be raised, my lord, in installments. We've served them notices. Every time we serve a notice, it stalls for a couple of days, and again, my lord, the construction resumes.
The matter is appearing on 11 January. Let this
11th.
also appear on the same date.
My lord, as your
Since
lordship.
I do not find
My
anyone
lord,
for the
but in the
respondents.
meantime, my lord, if your lordship would be kind enough to, my lord, at least direct the police authorities to, my lord, ensure that, my lord, your lordship's order is at least maintained. I won't be pressing for a rule today, if your lordship. My lord, Mr. Chatterjee is leading me. My lord.
Let the matter appear on 11th because the main matter is appearing on the 11th.
Yes, my lord. And kindly issues rule.
Today is 8th. It's 3 more days.
Please, please take.
Because I do not find the respondents today. Mr. Day has been appearing all through.
Yes.
But content to
Affidavit of service. None appears for the alleged contemner despite. Sir.
আচ্ছা বলছে দুদিন দাঁড়াতে এইসব এখানে থাকে না
Paragraph, let the matter appear under the same heading. On 11th January 2024.
in the meantime.
3 more days. Everything will be done on 11th. Don't worry. Next. Item 5.
I am for the petition, my lord. The state restoration application, my lord, on
Restoration?
20th January, your lordship passed this order.
Within
And I filed in 24th January, within time, my lord.
It's
restoration, my lord.
Can we deal with the writ petition now?
But only they have to serve a copy of the writ petition because we have already
They have no writ petition.
Please serve a copy.
I'll fix a date, my lord.
Can 1 of 2023. This is an application for restoration of the writ petition which was dismissed for default by an order passed on 20th January 2023. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 20th January 2023 is set aside. Paragraph, the writ petition is restored to its original file and number. Paragraph, can 1 of 2023 is disposed of. WP the order, let the matter appear. It's a group 1 motion.
One, my lord.
Let the matter appear under the heading group 1 motion on 31st January.
31st January, lordship.
Please serve a copy.
In the meantime, I shall. Deeply, lordship.
Next.
Your Lordship, we are for the petitioner praying for not this week.
It's your review application.
Yes.
Have you served?
Yes, the application has been served. Notices have been served.
For the response.
Kindly let the matter be appearing on 16th if possible.
On prayer of the, where is your service of the review application? The affidavit of service?
We'll produce that on the next
You're
day.
not ready today? On prayer of the petitioner, you're the petitioner. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 1st February.
1st February.
Next.
But I have got the petitioner hearing, my lord. My learned friend has filed on behalf of the 4 private respondents order for modification. My lord, say, my application.
What application is it?
My lord, this is the application for modification or recalling your lordship's order. Because of that, when the writ petition has been filed, they have not served the copy of the writ petition. As well as, my lord, I am coming, my lords, though the writ petition, original writ petitioner, my lord, the sell out this property against the, my lord, in favor of the 4, my lord, the applicant hearing before the lordships. So now suppressing that fact, my lord, that the civil suit is pending between the government authority and the, my lord, the writ petitioner. So now this the civil suit is, my lord, the order has already been passed. So now this is the civil suits. Now they have moved in the application
You
without.
are appearing for Pulak Haldar.
My lord, I appear, my lord, 2 application is there. One is the, my lord, this the, if your lordship kindly come to can 1.
Yes.
My lord, the can 2 is the, my lord, this can 1 is not, my lord, the vital, but the can 2 is the, my lord, the very relevant. Because of that, the respondent number, Borun Sardar, that is the respondent number 17 has filed can 2. Meditating that when the writ petition has been moved, I have not been served because of if the, my lord, the service was done by the, my lord, the writ petitioner, then the, my lord, the actual fact has to be brought before your lordship. A civil suit is pending between the parties. The land has been sold out by this, my lord, the writ petitioner, but that fact has not been brought before your lordships against the, my lord, the 4 parcels. My lord, kindly see a civil suit which has been, my lords, page 11. So, my lord, so far the other respondent is concerned, private respondent concerned, I have not, my lord, the come on behalf of them. Only I have come only on behalf of the, my lord, the 4 respondents. Respondent number 7, 8, 10, and 17. Admittedly, my lord, civil suit is pending. 4 private respondent. 7, 8, 10, and 17.
Civil suit is pending with regard to which property?
Demarcation in that property. In this
The same property.
Possible.
That was, you are appearing for the petitioner.
Yes.
So you did not state this before this court.
No, my lord, in my lord, actually, client is not, my lord, has not given, my lord, that is why.
So it has to be set aside. Suppression of material facts.
My lord, at this stage, my lord, against these 4 persons, I have no objection, my lord, to modification, my lord. My lord, 4 person has only filed. Other person, I am no. I am not on behalf of the other persons, other private respondents.
No, no, if the same property is involved in a civil suit, how can the writ
No,
pass an
there
order?
is the, my lord, the part. 157 is the original property. He sold out that portion from that portion. Other part is so far that is the government land. That we are not. I am not on concern about the other part.
Who is appearing for the state?
I am for the state.
Yes, what is your submission?
My lord, already my lord, assistant engineer, Jayanagar, PW, Jayanagar division, there says the all are enclosed are removed.
All encroaches are removed.
Removed, no more.
No.
As per order, my lord.
Demarcation only. My lord, the 10-1 notice has been issued. So after
It was already issued when the writ petition was filed. Writ petition was filed after issuance of 10-1.
no, my lord, no. So for the my
Second paragraph.
no, my lord, they have filed, my lord, that
This is the 10-1
Now
notice
therefore,
that you
now
showed.
therefore, my lord, now therefore is exercise of the power.
that is also notice.
Section
This is
6
the
and 10.
notice. And the writ petition was filed. What are you submitting, sir? You do not have the instructions also.
My
The writ petition records that 10-1 notice was issued. And this is a stale document. Any further instructions?
No, my lord. No. Only my lord, November 17, taken instruction.
What is the date today?
Yes, my lord, I have taken instruction, my lord.
Let the state come back with instructions.
So, my lord, in the meantime, no court steps.
Admittedly, my lord, these are suppressed.
My lord, against 4 persons only, my lord. Civil suit is pending, my lord. After that, I have come to know that civil suit is pending, my lord.
No pursuit. I am not
But-
paying for stay of operation of your lordship's order. No pursuit stay against the 4 persons.
If there is suppression of material facts, the
Everything-
entire writ petition goes on this ground. No relief can be granted to you.
My lord, rest of the petitioners.
Can you,
rest of the
can
prior-
you segregate
Withdraw-
rest and
withdraw-
this? There has been suppression in the
withdraw
writ
to the-
petition. So you're not entitled to any relief at all.
Then, my lord, kindly grant me leave to I petition against the rest persons, my lord. Because, my lord, there is no.
That leave is
If
already
your
there.
lordship set aside this order, he has the liberty to file, may be filed.
Can one or can two actually? In both can one and can two, it's the same prayer, isn't it?
Respondent 7, 8, 10, 17. That's 4.
7, 8.
10 and 17.
The applicants, but only 2 of them have filed the application.
My lord, 2, because of that, I appear on behalf of the all other, that respondent. 7, my lord, 7 is all. Because of that copy, I not their formal application.
Application is
Only 2.
Only 2.
Only 2. But I appear on behalf of, because of respondent has given power, they have not individual.
No,
Lordship,
no, you
lordship.
cannot appear without an application.
So, my lord, this is when the power.
Application filed on behalf of 2 persons.
Yes, so I can deal with
civil
only
suit
2
pending
persons.
So, my lord, yeah. But you record my submission because of the 4% jointly file a civil suit. That particular respondent. 7, 8, 10 and 17.
It is submitted on behalf of the applicants. This is Tanmoy Mondol. How has the son applied? His
Malad,
father-
the son is the owner, but his father made a party. Father, Malad, the son, Tanmoy is the owner of that particular land. So now he has filed a writ petition against his father. Though I am the Malad, purchased the land from the petitioner.
Submitted on behalf of the applicants that the father of the applicant Tanmoy Mondol তার আগে
ছেলে।
পরিমল মন্ডল কমা ফাদার অফ দ্য অ্যাপ্লিকেন্ট তন্ময় মন্ডল করো ওটার আগে পরিমল মন্ডল কমা ফাদার অফ অ্যাপ্লিকেন্ট তন্ময় মন্ডল and Borun Sardar were impleaded as party respondents in the writ petition being WPA 1416 of 2023, which was disposed of by an order passed on April 19, 2023. Learned Counsel submits that the applicants as well as respondent numbers 7 and 8 of the writ petition filed a title suit in respect of the plot involved in the writ petition against the petitioner.
And government authority, Malad, 7, 8,
7,
8, 10 and 17.
Yes. Against the petitioner and government authorities, which is pending before
the learned civil judge, junior division,
before the learned civil judge within bracket junior division, comma,
first civil judge, my lord, the junior division at Diamond
First
Harbour.
court.
At Diamond Harbour.
first within bracket junior division, bracket closed, comma, first court, Diamond Harbour. This fact was suppressed by the writ petitioner before this court in obtaining the order dated April 19, 2023. The writ petitioner is, comma, therefore, comma, guilty of suppression of material facts before this court. Paragraph. It is admitted on behalf of the writ petitioner that the title suit, as stated by the applicants, is pending before the civil court, and learned counsel was not instructed to that effect by the writ petitioner. Stop. Paragraph. In view of the submission made on behalf of the writ petitioner, comma, this court is inclined to hold that there was suppression of material facts on the part of the writ petitioner in not apprising the court of the title suit, which is still title suit filed in respect of the plot involved in the writ petition, comma, which is still pending before the civil court. Stop. The writ petitioner is, comma, therefore, comma, guilty of suppression of material facts and has not come to court and did not come to court, dispose of it, and did not come to court with clean hands. Stop. As such, comma, the writ petitioner is not entitled to any relief in the writ petition. Paragraph. In view of the above, the order passed on April 19, 2023 is set aside.
Leave may be granted, my lord, to these persons, sir.
I'll impose costs, sir, instead of leave.
My lord,
Pay cost of rupees 10,000 for suppression.
actually, my client is not.
The cost is on your client, not on you. There is gross suppression, isn't it?
My lord.
Yuvanam? Is set aside with cost of rupees 10,000. Paragraph can 1 or 2 to 27 are accordingly disposed of. Urgent certified website copy.
Grateful.
Next.
দুটো ক্যানই হয়ে গেছে।
My lord, I am for the petitioner.
Yes.
My lord recollects this matter where I have made a
Stage of argument.
it is in the stage of argument, but the prosecution has recalled some witnesses. So I made this submission today before the Honorable Division Bench, and I pressed for bail. My prayer was rejected, and there was a direction passed upon the learned trial court to expedite the matter and to finish it preferably within 3 months. My lord, that is one part. The direction is not on your lordship, it is on the trial court. My point before your lordship is that whether if one order of remand is illegal, then all the orders subsequent thereto falls. My lord, to that extent,
That has been your submission also.
that has been my submission, my lord. On that point of law, my learned friend is supposed to make his submissions.
State has not, my lord, established or constituted a special, a designated court. Lord, in terms of section 22(3), till such time, my lord, it is not constituted. The sessions court, my lord, will have the jurisdiction and they will be competent.
22(3) of the CRPC. NIA.
Now, my lord, this case, your lordship, I'm just filing a notice of argument in the form of list of dates. Well, the remand, my lord, is for the purpose of protection of the accused in custody and for ensuring fair investigation. Now, but the investigation has not been questioned by this petitioner. Only point which they have taken is that the additional district session judge is not the sessions district judge.
The jurisdiction is
The
questioned.
jurisdiction is part of concern. But my lord, additional session judge, with due respect, my lord, is not subordinate to.
No, I think learned counsel has made an earlier point, that is the first remand was made by the magistrate.
Yes, yes.
Who was not empowered.
He was not empowered, correct.
That was your initial
point. My lord, that is an irregularity for which he is entitled to bail. He is entitled to bail. Now, my lord, after the matter was committed, after the cognizance was taken by the sessions court, after charge was framed by the sessions court, my lord, now the next point which is taken up is, why was it transferred to the additional district session judge? Now, as far as the law is concerned, my lord, the post of additional district judge is not subordinate to the district judge, as your lordship knows. No, and therefore, my lord, the point which they have urged that the trial will stand vitiated is not at all correct. It is not tenable at all. So far as the remand part is concerned, if there is an irregularity also, that will not vitiate the entire trial. Inasmuch as, my lord, no point has been taken with regard to that they are prejudiced by the investigation or by the trial, my lord, continuing by the additional district session judge. Now, I have, my lord, stated in my notes of argument in the form of list of dates. And I have also collected, my lord, as far as possible, the orders, my lord, which your lordship may have the occasion to go through, my lord. And confirm.
These are annexed to the petition. Petition annex.
No, these are the orders of remand, framing of charge, cognizance, everything, and transfer.
The day-to-day orders.
Yes.
Didi. That's all your submission.
Yes,
My lord, in reply, I state that my point is not with regard to the trial being conducted before additional session judge. It is about after addition of UAPA, whether the magistrate had power to remand. I have shown your lordship that after addition of UAPA, page number.
You have given your judgments on the earlier date?
Yes, my lord.
That is with regard to the
I have
bail.
No, not with regard to bail. There are two judgments. One of the Honorable High Court.
What is this? Mr. Ramit?
Well, these are the day-to-day orders.
You have given these are the orders.
There are
two sets.
One, my lord, is covering, my lord, the cognizance, and the other part, my lord, when the charge was framed. I've just flagged those.
Yes.
My lord, I have cited three judgments. One is of the Honorable Supreme Court, where the Honorable Supreme Court held in the case of Bikramjit Singh, where they held that the magistrate do not have power. The same view, by considering Bikramjit Singh, has been reiterated by the division bench of this Honorable Court. I have cited that judgment also. My lord has got a copy, my lord.
I think you have given.
দিদি একটু দেখুন না জাজমেন্ট গুলো আগের দিন তিনটে জাজমেন্ট দিয়েছে ফাইলে আছে কিনা
They can include judgment. Bikramjit I can find, but the other two judgments.
And my lord, the third judgment that I referred to was the judgment passed by the Honorable Single Judge of this Honorable Court, which was not relating to bail. আরেকটা কপি আছে তাহলে না পেলে পরে না জয়িতা না
I commence with the framing of charge.
জয়িতা না
Oh, you have, yes. All the three are tied together.
Yes, I believe together they should be together, my lord. So my lord, first is Bikramjit, the second is a bail order where the Honorable Division Bench held that the magistrate do not have power, and the third, my lord, the case of Joyita Dash, CRA,
Yes.
CRR 3180,
And the other one is Pratik Bhumik.
Pratik Bhumik. That is the bail.
That's the division bench.
That's the division bench order.
They're all here.
Yes. So in Joyita, it was not a case of bail. The whatever may be the stage in this particular case, I say that on a point of law, if there is an irregularity which is brought to the notice of the Constitutional Court, my lord, I humbly submit that that wrong has to be remedied, even if it is brought at any stage, because with regard to a point of law, and this is not an irregularity, this is an illegality which has already been held by the single judge. My lord, in view of that, my lord, my prayer is that this particular order of remand be set aside. Grateful, my lord.
Reserved.
My lord, there is a judgment of the Supreme Court, Nasir bin Abu Bakr is like.
You have
My lord, a judgment of another case has been referred. May I just read it in page paragraph 46. The court held that if there for cognizance in fact taken on a police report initiated by breach of mandatory provision relating to an investigation. But I'm on the point, my lord, mandatory provision has been violated. Now, there can be no doubt that the result of the trial which follows cannot be set aside unless illegality in the investigation can be shown to have brought about a miscarriage of justice. Nowhere in the within the four
So, my lord,
of the proceeding.
my learned friend,
illegality.
my learned friend, after my reply, has cited a judgment. My lord,
This has been referred in all
no,
those
I am aware of this judgment. My lord, in this judgment, as my learned friend has pointed out, is regard to cognizance. I am not on cognizance. I am on remand. These two things are different in the eye of law.
Remand is not the trial, but the trial starts from the framing of charge.
I'll consider.
Grateful.
Argument concluded. Judgment received. Next. এর আগে সিএ ম্যাটারে যেন ফাইলটা যায় এর আগের দিন অর্ডার শেষ করে গেছে স্যার
Item number 9, I beg to appeal, my lord, for the petition in this matter. On the last occasion, your lordship.
that matter.
Yes, yes. Lord, I have.
The other matters fixed.
Yes, yes. Lord,
That's
I
not
have.
coming up
The
at all.
problem is elsewhere. Lord, may I file the affidavit of service pursuant to lordship's direction? I have served upon the learned AG. Lord, there are three, my lord, writ petitions, bunch of writ petitions, which your lordship was hearing. I have collected the name numbers. So, my lord, what happened on the last occasion that was heard on 24th of March 2023? Lord, this is the last order.
The other ones.
The other bunch. একটু জজ সাহেবকে দেবেন না এটা?
And when was the next date fixed?
Yes, the problem is, in that matter, your lordship, because of the pendency of the division bench judgment, your lordship stalled the hearing. The same thing. Lord, thereafter, this development has happened.
What about the division bench judgment?
Lord, I have indicated that's why these matters are being taken up. So, Lord, if this matter could be, Lord, tagged with these matters, so that, Lord,
Division bench has disposed of.
yes, yes, it's finished. It has been relegated to the single bench again to be heard out on merits. The issue was with respect to giving an interim order before the division bench, where, my lord, also the Rule 61 was in question. Now, my lord, basing on that, my lord, all honorable single benches were adjourning the matters. Now, my lord, this is again the same thing that has happened. My lord, thereafter, division bench has disposed of. That's why, my lord, I have 2-3 matters also on the same.
That matter has come back before this bench.
Yes, has to.
Yes.
Has to.
How many matters are there in all?
Lord, these are the 3 matters on which your lordship had substantially heard the learned advocate general and Mr. Aniruddha Chatterjee was making the submission. For the
Heard and forgot.
yes, 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 all.
Just be heard again. Heard long back.
Lord,
I've taken notes.
Lord, if these 3 numbers, Lord, all this bunch can be tagged together.
And AG has been served.
Yes, yes, Lord, I have filed the affidavit service, Lord.
Please take a note. It is submitted on behalf of the petitioner that 18th matter pertain to similar issues as in the present writ petition. 18th number de paragraph in view of the same. All these matters be taken up for consideration. When will you come back?
Lord, as and when convenient to my lord,
9th February? Please inform in the meantime. Time is difficult in this court. Come back, let us see.
I'm grateful.
Nothing George. Item 10, my lord, I am for the petitioner.
Lordship, in this matter, Mr. Bihani is appearing for the state
This is
respondent.
my
Lordship.
affidavit of service. What happens in this writ petition, my lord, the private respondents erected the Paka
Have you
structure.
served the private respondents?
Yes, that is affidavit of service. 2 times I have signed. And they received it.
Yes, they've received it.
My lord, I am the petitioner is the owner of a house beside the state highway. The private respondents, my lord, erected the Paka structures constructed with 2 rooms and used to run a hotel. My lord, the private respondents blocked the ingress and outgress of the petitioner. Now the petitioner filed an application before the learned executive magistrate for removal of that blockage area and demolition of the structure. Also filed the petition before the assistant engineers, state highways, public works department, and also subdivisional magistrate. On the basis of that application, my lord, the learned executive magistrate passed the order of demolition. As well as, my lord, the learned subdivisional magistrate also passed the order of demolition. It is also kindly come to the page 5. And my lord, directed the police authorities as well as block development officer to demolish the structure raised by the private respondent. Accordingly, private respondent raised the half structures, demolished the half structures with their own fund. And half structure, 1 room is still standing upon the said state highway. My prayer is, let a direction be given upon the police officer, my lord, to appear before the spot and, my lord, demolish the rest structures. My lord, there is direction by the learned subdivisional magistrate, and an hearing was also given to the private respondents.
You are asking for implementation of this order.
Yes.
Lordship, in this matter, Mr. Bihani is appearing for state respondent. Lordship, due to some personal difficulty, he is not attend on first of Lordship. I am prayer only not today, Lordship.
He is only asking for implementation of this order.
Yes.
What is the difficulty?
As you, Lordship. As you, Lordship.
Affidavit of service. Learned, the petitioner prays for implementation of the order under section 10 within bracket 3 of the West Bengal Highways Act 1964, passed by the subdivisional magistrate, Jhargram Shodor on 23rd
February 2023.
Learned counsel for the petitioner submits that the private respondents encroached upon private respondents have raised unauthorized construction by encroaching upon a portion of the state highway adjoining his property, thereby obstructing his egress and ingress. Stop. Pursuant to applications made by the petitioner in this regard before the
subdivisional magistrate as well as before the assistant engineer as well as subdivisional executive magistrate
before
and
the
all
concerned authority, proceeding under section 10 of the West Bengal Highways Act 1964 was initiated, and by an order passed under section 10(3) of the Act, The Subdivisional Magistrate, Jhargram Shodor,
Subdivisional Magistrate Jhargram, District Jhargram.
directed the concerned authorities to demolish the unauthorized construction upon deploying adequate police force for maintenance of law and order during such demolition. Stop. Learned Counsel submits that a portion of the unauthorized construction has been removed by the private respondents after the said order, but the entire unauthorized construction is yet to be demolished. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since an order of demolition has been passed by the subdivisional magistrate on 23rd February 2023 under section 10(3) of the Act of 1964, who will do the demolition? The assistant engineer?
Assistant engineer with the police help.
Assistant engineer, Jhargram, being the sixth respondent here in be directed to implement the said order and cause demolition of the entire unauthorized construction on the state highway within 1 month from the date of communication of this order. Stop. The police has not been made a party.
No, my lord, police has not been made.
Should be the SP Jhargram.
SP.
Paragraph, the superintendent of police,
SP Jhargram.
Jhargram, is directed to render all assistance.
Murad, I'm sorry to disturb, Murad. I've been able to join, but I pay for the state respondents.
Yes, an order under 10(3) has been passed.
I tell you, Lordship, Murad, because the first difficulty
of the order.
The difficulty was that, Murad, I did not know the matter will appear today. I was not put on notice, but I took instructions yesterday night. An order under 10(3) has been passed by the SDO. Murad, my instruction, though not written orally, is that, my lord, after the order under 10(3) was passed, my lord, here the private respondents, my lord, took up an application before the district magistrate. The district magistrate rejected their appeal. After that, my lord, my lord, 2 dates were fixed for demolition. On the first date, the police sought for another date because they were preoccupied, and then ultimately, I've been told over the telephone yesterday night by the executive engineer that the private respondents themselves have removed the unauthorized construction.
A portion.
A portion.
That is the submission of the petitioner.
That also have taken instruction. I sought to take instructions. My lord, I have been told that when a tenant inducted by the private respondent is maybe allegedly over there also. My respectful submission is that everything is over telephone. That if that is the case, then Lordship will also consider whether, my lord, the places pointed by in the writ petition has been removed, then whether a fresh section 10 proceedings ought to be initiated again or not.
The entire construction has not been removed.
Well,
only a portion has been removed. That is the submission.
May I come back with written instructions? May I come back with written instructions?
Not necessary. I'm giving a direction for removal of the entire unauthorized construction in implementation of the order under 10(3).
No, Lord should do that. But I was only because all these things of the appeal being rejected, my lord, and we have taken steps. So, my lord, this, my lord, if I can put this on record.
Not necessary. No need to keep it pending only for that reason, isn't it?
Very well.
I'll record your submission.
My lord, but these all told to me orally over the phone.
I'll record your submission on instructions.
Lord. My lord, subject to correction, may record that I have been instructed that an application was made before the district magistrate, which was rejected and subsequent has been turned down, and subsequently, my lord, I have been instructed that the private respondents have removed their, but then lordship can record, my lord, subject to correction that he says this. I'm sorry to be joining late, my lord.
Keep on. এই জায়গাটা না শেষ করলাম কি দিয়ে? ও render all assistance, তাই তো? All assistance in implementation of the order. আচ্ছা ওই এইটার আগে ওই upon consideration এর আগে একটা প্যারাগ্রাফ ঢোকান, learned counsel for the state respondents submits that the private respondents preferred an appeal against the order under section 10(3) of the Act of 1964, which was turned down by the district magistrate by an order passed under section 10(4) of the Act. Stop. The private respondents or the submits যেখানে বললাম ওখানে on instruction. Submits, comma, on instructions, comma. The private respondents have demolished the unauthorized construction standing on the state highway. Upon consideration.
Lordship, I'm deeply obliged. My Lordship has fixed any time limit. Lordship
In 1 month it will be
time
implemented.
limit.
Yes.
Lordship. Well, your Lordship grants little more time because Lordship knows that. I leave it to your Lordship.
Demolition. 1 month is sufficient.
Very well, very
I
well.
was planning 2 weeks.
Some
No, no,
portions
very-
is standing there on, some portions is standing there.
Some portion has been demolished.
Yes,
Very well.
that to be
Very
demolished.
well, very well, very well.
But kindly keep the order in record, which I have
So
some.
at the line একদম শুরুতে করুন. The order under section 10(3) of the West Bengal Highways Act 1964 submitted on behalf of the petitioner is taken on record.
I'm deeply obliged.
Deeply.
Next.
Well, I am for the petitioner in this matter. Video service করা আছে? Malad, দিয়ে দে।
Yes.
A proceeding under LA Act was initiated for acquisition of the property as far back in 1962. 1962. Malad, till today possession has not been taken. Malad, without taking possession, property was handed over to Kolkata Port Trust. Kolkata Port Trust initiated a notice of one of the petitioner against and obtained an order under Public Premises Act for eviction.
This is not complete. Item
Service?
dispatched. I find only
Track
2 track reports.
Track record shows delivery.
2 track reports.
Land state is the only authority.
Where is the service on state? No, municipality is there, Holdia is there.
Municipality is supporting me. He has given me trade license, therefore I have
Serve.
given it.
Serve and come back.
Served হয়নি complete? না পোস্ট তো করেছো স্যার, রিটার্ন এসছে সার্ভিস 30 days ballot under the civil procedure code if not receive ballot deemed served.
Please serve and come back.
Huh? During COVID it was served. That was the all.
During COVID it was served.
Yeah. 2020 case.
Please serve afresh and come back.
Give a date then.
I'll give a date. Please.
Thank you.
Since service upon the respondents is not complete, comma, let the matter stand over till 1st February. Let the matter stand over till 1st February.
Grateful. Sorry.
And there is no service on state also, GP's office.
Huh?
I think, you to serve the GP's office. 12 adjourn.
GP কে দিয়ে দেন একটা স্যার।
Petitioner ছিল। 12, the petitioner sought an adjourn.
Item number 12, I am for the petitioner, my lord. Mr. R.K. Chaudhary, advocate, was counsel in this matter. He was passed.
He is not a party. A state officer is a party. Kakra Port Trust party, municipality party. Let go.
My lord, he was passed away on 30th December. So we need some time, my lord, to engage someone.
Very good. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16th February. 16th February. Okay.
Lord, item number 13, I appear on behalf of the writ petitioner. Lord, the subject matter is a land, my lord, situated at PT Road. Middle.
What about the others? So Bandyopadhyay, you're appearing. And for 2 and 3?
2 and 3, Mr. Chatterjee, my lord, is represented.
Yes.
Lordship. The land in question was purchased by the respondent number 4 from Indian Oxygen Limited.
My lord has heard, my lord, this matter substantially. My lord, this is the matter where, my lord, similar points, my lord, were pending adjudication before the Honorable Division Bench presided over by, my lord, Justice GHOSH. My lord, it will, my lord, just come back to my lord's mind. Where, my lord, the decision, my lord, has been taken in our favor. But, my lord, for their peace of mind, my lord was hearing them.
Lordship. Lordship, the land in question was purchased in the year 1993. My lord, there was an order of exemption, my lord, by the authorities. If your lordship kindly takes page 53 of my writ application.
Yes.
Lordship, may I please? Please refer to your letter dated such and such. It appears that you have sought permission for transfer of the electrode factory with all its building, plants, land, including excess vacant land, employees, etc., located at Khorda as a going concern to ESAB India Limited. That is the respondent number 4, my lord, which will continue to do the same manufacturing activity as IOL has been doing and the same workforce which IOL had been employing at Khorda, and will also utilize the excess vacant land at Khorda for industrial purposes, complying with all the provisions of the Urban Land Ceiling Act. It further appears that such a transfer will safeguard the interests of the employees and the workers of the ongoing concern, and therefore will be in public interest. In view of the facts stated above, and in consideration of all relevant facts and circumstances of the case, I am directed to inform you that the governor is pleased hereby to exempt under section 20 subsection 1A of the Urban Land Ceiling Act the excess vacant land as described in the schedule below from the provisions of chapter 3 of the act for the purpose of transfer to ESAB Limited subject to the following conditions. Now, my lord, the conditions. The transferee company, that is ESAB India Limited, shall not use the excess vacant land after transfer for any purpose other than industrial, that is welding business consisting of manufacture and sale of welding electrodes and equipments of various types. The transferee company shall not, without formal sanction of the state government, transfer this excess land as described in the schedule below by way of sale, gift, mortgage, other than the mortgage without possession in favor of banking or other financial institutions referred to in section 19 of the Urban Land Ceiling Act for raising loan for the purpose of industry. Thereafter, my lord, if I may place clause D, on breach of any of terms and conditions specified above in respect of the lands, the exemption granted under this order shall be liable to be withdrawn in pursuance of the provisions of subsection 20 of the Act. My lord, this is the exemption order. Thereafter, land was transferred by Indian Oxygen Limited to, my lord, the respondent number 4. My lord, the conditions which are enumerated in the, my lord, exemption order were made a part and parcel of the transfer deed. If your lordship kindly takes page 88. My lord, at page 88, point number 6.
Yes.
Lordship, the transferee shall comply with all conditions of exemption contained in the order dated 29th October 1992, issued by the Government of West Bengal Land and Land Reforms Development Department, giving permission for sale of land at Khorda in favor of the transfer. My lord, this is the order that I just placed before your lordship. Thereafter, my lord, in 2015, 15 July 2015, my lord, the factory that was being run by the respondent number 4 was, my lord, closed down. This is at, my lord, page 108 of my writ petition. This is the closure notice. May I please?
Yes.
Closure of factory situated at Khorda at the close of office hours on Friday, the 14th August 2015. Dear sir, we have two plants in Kolkata, one in Nagpur, Chennai. With increasing manufacturing costs and dropping sales volumes, our financial viability has been under severe strain. After a lot of deliberations and considering various options, we felt we should integrate the manufacturing facilities to enable us to meet the market demands from 4 manufacturing facilities by winding up operations in the 5th plant. This would significantly reduce our costs without affecting our business and hence can make us more competitive in the market. After a very detailed internal review, we decided to wind up the operations in our Khorda factory. We have announced a voluntary separation scheme for 28 workmen on the rolls of the company. Considering all the facts and circumstances, we wish to inform you and place on record that we will close down the Khorda factory at the close of office hours on Friday, 14th August 2015. So therefore, my lord, one of the terms of the exemption granted was that, my lord, a welding business would be carried on at the factory. Now, my lord, after this closure, my lord, the land, my lord, goes back to the state. My lord, in such circumstances, my lord, we had...
My lord, interrupt for a second. My lord, all these have already been shown to your lordship. My learned friend is, my lord, my next door neighbor. My lord, the preliminary point of objection, the point of demurrer that we have taken, my lord, is that he doesn't have any say whether, my lord, my exemption is liable to go or not. My lord, on the same, my lord, accusation, my lord, 2 separate proceedings are initiated. I am really sorry to my learned friend. I am just indicating, my lord, giving your lordship a bird's eye view. My lord, against conversion, my lord, they suffered a defeat before BL and LRO, before my lord, ADM DL LRO, then before Land Reforms Tribunal, then before the Honorable Division Bench. My lord, everywhere, my lord, this has been held that, my lord, he doesn't have any locus, even, my lord, to raise his voice saying that, my lord, I have violated, my lord, the conditions of exemption granted under the Urban Land Ceiling Act. Now, my lord, having suffered a defeat there, now, my lord, they are after me, my lord, under this Urban Land Ceiling Act, where also they have suffered a defeat before, my lord, both the 2 forums below your lordship. My lord was, my lord, kind enough, my lord, to ask them, my lord, to indicate what locus, my lord, do they have, my lord, to
My lord, I
challenge
will
this.
answer locus. My lord, may I continue with my arguments? Yes. My lord, in such circumstances, my lord, we made a representation, my lord, to the joint secretary. My lord, this is at page 270. Your lordship will kindly take this for once.
Yes.
My lord, page 217, my lord, will see the subject, violation of conditions imposed vide your order dated 29th October 1992 while granting permission for exemption under section 20 of the Urban Land Ceiling Act. My lord, will kindly take page 219.6. While ASAP was bound to follow and comply with the conditions as imposed vide your order dated 29th October 1992, however, there has been deliberate non-compliance and violation of the same by ESAP inasmuch as the exemption granted specifically mentioned ESAP shall not use the excess vacant land for any purpose other than industrial with welding business consisting of manufacture and sale of welding electrodes and equipments of various types. However, ISAB has stopped its industrial activities at the said land for the last 4 number of years and has entered into an agreement with a property developer.
Yes, but the same question still remains. What is your locus?
My lord,
How are you challenging the violation of ISAB?
My lord, from this representation, my lord, this was rejected. My lord, we went up in appeal. Your lordship recalls there was an order, my lord, directing the ULC authorities to get certain documents. Only the hearing would be continued thereafter, which was not done. Your lordship will kindly come to page 413 for one.
Objection was that it was heard without the documents being
Lordship, I'm on the procedural irregularity first.
The preliminary question is what locus do you have to challenge this?
My lord, I am an adjacent landowner. My lord, there is a subsisting policy of the government which says, my lord, that the land which is resumed, my lord, is possible that it is allotted, my lord, for industrial purposes. My lord, I will satisfy your lordship on locus, but your lordship will kindly take note.
First on locus, please, then on merits.
Lordship.
Because if you have no locus, merits will come in immaterial.
Lordship, locus, your lordship, locus, in my humble submissions, would have to be decided by the, my lord, authorities below. Thereafter, would lordship, your lordship would enter into that question of locus? My lord, I am entitled to an hearing before the authorities. My lord will kindly see the manner in which my lord, the proceedings have.
Why are you entitled to a hearing before the authority?
My lord,
some interest.
Lordship. The representation which we filed earlier was not being concerned, which is when we approached your lordship's court by way of filing a writ petition. Your lordship will see that there is an order passed on 8 November 2019 at page 225 of my application.
Yes. This was only for consideration.
Lordship.
The locus was not raised. That point was not raised at all.
Lordship, so therefore, I am at least entitled to an hearing, proper hearing before the authorities below. My lord, I am on the procedural irregularity that has, my lord, unfolded. My lord, will kindly take page 413, the order passed on 21st January 2021.
Yes.
Your lordship will kindly turn to page 414. My lord, heard all concerned. My lord, this is at the middle of the page. Since the advocate of ISAB India raised a different angle beyond the issues incorporated in the appeal, stating that the subject factory premises does not include any excess vacant land, he was directed to submit a written statement justifying his claim at the earliest. Then, the competent authority and the SDO Barakpur be asked to confirm whether any NOC as mentioned by ISAB India Limited has been issued from his end, and if so, a detailed report showing the basis of issuing such NOC be submitted to the UD and MA department at an early date. The departmental authority would examine the matter and offer views in this regard. Let ULC branch under UD and MA department be asked to inform whether any prayer for change of purpose from welding business and ancillary, as mentioned in the previous exemption order to ISAB, to industrial park along with DPR of the proposed project duly vetted by the MSME department has been received and duly examined. On getting written statement from ISAB and report from the CA Barakpur and the ULC branch under UD and MA department, the matter would be heard again.
The matter was heard prior to submission of these.
Lordship, on a date which was not fixed for hearing when the documents had not come. My lord will kindly take the order dated 19th April. My lord, Mr. Mitro is leading.
May I fully answer because there will be no repetition. It was what you calculate. You can see. Page 431 is really what I am concerned with. From the third paragraph, that is in response to the allegations made by the appellant, that ESAB has violated the provisions of the order of so and so. Order dated 29th October, the ULC authorities in Urban Development Department informed that since no such proposal for change of business purpose or initiation of new projects was received by ESAB India Limited, and it was reported that ESAB has stopped functioning since 2015. One notice by 268 so dated 5th April 21 was issued by the authority concerned to the said company asking to show cause for non-compliance of the order dated 29th October 92. And ESAB has duly submitted the reply, which is under scrutiny of the ULC authorities. As in the appeal petition received on 18 February 2020, the appellant countered the stand of ESAB Limited that IOL had mistakenly taken exemption on Section 20 of the ULC. And as in the last date, 21st January 21, the advocate concerned on behalf of ESAB claimed that they have obtained one NOC from the competent authority SDO that relaxes the provision of excess vacant land within the subject land. The authority concerned in the UD and MA department sought report from CA and SDO regarding issue of NOC towards excess vacant land. The departmental officers informed that the reports of the CA and SDO are under scrutiny of the ULC authorities. Or she kindly comes back for a second to page 414. Yes. Lordship, the last three paragraphs, this was supposed to be submitted before the matter is taken up. Yes. This report, Lordship has seen that. So now, Lordship, next paragraph. Now, after going through the petitions as well as written statements submitted by both companies, getting heard of them and taking information from ULC, it is observed that reference of the conversion case number so and so on filed under 4C of the WBLR Act does not have relevance to the instant case filed under ULC. Let that matter be judged by the authority concerned, empowered by law to dispose of the matter. Under the purview of ULCR, it is only to see whether the provisions made under this act are followed by landowners who possess a quantum of excess vacant land within their landed property. The ULC authorities in UD and MA department have taken up correspondence with ISAB on the matter of utilization of the exempted ceiling excess land measuring 21,000 square meters within its factory premises at Khorda, and also started communication with the CA and SDO Barrackpore on the matter of issuance of NOC on the said excess land in favor of ISAB. The matter of grievance of or displeasure or concern that leads the appellant to file petition under 33 of the ULCR, it is not established. It is not established. Flouting of order of 29th October, if occurred, is entirely related to ISAB India Limited, for which concerned authority has already initiated action, and as such, with only having its factory premises adjacent to ISAB, is not sufficient enough to prove the appellant company has agreed. Moreover, neither the appellant company has been able to produce any document or any report from the CA and SDO who is the local authority on ULC matters, indicate that the instant that the interest of the appellant company is hampered, that the last paragraph it is rejected. But my submission, firstly, is that this was not the matter could have been heard after receiving the report. That was the direction of the previous direction. No one challenged it. So, but this was a premature hearing without getting the reports, and I'm covered by judgments that if the matter is heard at a time when it was not ready, it was not supposed to be heard because of any earlier order. On that ground alone, the order impugned has to be set aside. That's my first point. Of course, I will not shy away from showing at least prima facie that I have a locus, that I have the locus standi, and if I go back to the authority, I will be able to show I have locus standi because this was on a date not fixed. And Lordship, this is especially true. So we were not ready to argue the case on the merits because we were waiting for the reports to come. The reports had not come. So then if the matter is taken up, and of course I will also deal with Justice Boshak's judgment, which I will show has expressly excluded the applicability of the judgment to the ULC proceeding and the matters arising out of ULC. In fact, the judgments which I had cited for Justice Boshak on ULC law and as to whether that was already vested or not, his lordship expressly said that I'm not going into this is the matter of ULC matter. So I'm not going into this. I am only deciding on the point of Section 4C of the land reform. So, my first submission, I go back. So I shall first address on the whether it could have been taken up and on this date before the reports came, and if so, what is the consequence? Lordship. Wrong question. আমি বেগুনি হয়ে যেতে পারি সেটা তোমার সিনিয়র হলে লাল হতে পারে দেখাই সুমানা নাকি একটা
Mention that is me.
সুমন বাচ্চা আমার সেকেন্ড আইপ্যাডটা So the first judgment I am relying upon is that of her ladyship, Justice Shampa Sarkar, the unreported judgment. Short judgment, I shall show paragraph 3 first. Paragraph 3, this revisional application challenges the procedure adopted by the learned tribunal while dismissing the essay. The attention of the court is drawn to the order dated 19th February by which the learned tribunal fixed the matter for hearing on 26th of February and extended the interim order till the next date of hearing. The matter was not taken up for hearing as per record on 26th of February, but the matter was next listed for the learned tribunal on 17th March. The learned tribunal fixed the matter along with the interlocutory applications within the first 10 matters on April 6, 7, 8, between 12:30 and 1:30. It appears that the matter was placed on 26th March in the list of judgment when the parties were present and the petitioners objected to the proceedings being continued on that date. The learned tribunal pronounced its judgment, thereby dismissing the essay and dispose of the application. Paragraph 5. The facts as narrated here and above clearly show that the tribunal did not proceed in accordance with law and has caused grave injustice to the petitioners by pronouncing the judgment on a day not fixed by the tribunal itself for hearing. The tribunal had fixed 3 consecutive dates for hearing of the matter by an order of 17th March. Instead, on a prior date, the judgment was pronounced when admittedly no hearing was held. In view of the fact that the application before the was dismissed without granting. So this was dismissed. Now, my lord, the next judgment, Assam. All India Reporter 1953 Assam 150. Paragraph 4. I am going to dispose of the matter on the first objection raised on behalf of the petitioner.
Paragraph 4.
Paragraph 4. I am going to dispose of the matter on the first objection raised on behalf of the petitioner. It is clear from the order sheet that 16th March 50 was not the date fixed for hearing of the suit, but it was only for production of accounts by defendant number 1 for settling the matter as indicated by the order of 21st January 1950. The learned municip was quite within his rights in dismissing the application for further extension of time for production of account if he did not believe the prayer to be bona fide, but that it did not entitle him to fix the next date for an ex parte hearing, the production of accounts being for the purpose of settlement. But both parties should have got sufficient notice as to the date fixed for hearing so that they might have been present with their witnesses and have them duly summoned if they wanted to, since the chance of settlement has vanished. An ex parte hearing is provided only when one of the parties is absent on the date of hearing as indicated above. The result of the non-production of the accounts would have been a presumption to the effect that there will be no settlement or there was no account, or in case the accounts were produced, they would have gone to settlement. In this case, it could not be said that to be the act necessary to further progress of the suit in this view of the matter. Fixing up a date for an ex parte hearing in the absence of one of the parties and under the present circumstances was improper. Lordship kindly in this context takes page which Mr. Banerjee possibly had placed is page 415. Page by the 416. 416.
Yes.
Sorry, page 41. 41. Oh, you can give me 1 minute. Page 415. 415. 415, yes. 16 April 21, page 415. We are in 415. We are in notice. We are in receipt of your notice for hearing on 19th April. This notice was received, page 412, on the same date, on 16th April itself. 412, notice was received for hearing on 19th April. 16th April, 412 notice. Now, this is our response. Same day we write back. However, please note that the pandemic situation is quite grave at the moment with extreme surge in COVID. Well, the first part is not that important. Lordship kindly comes to the pandemic issue was there. The fifth line. Furthermore, even though a detailed hearing at ad interim stage was held on 21st January 21 by you, yet, despite lapse of almost 3 months and our request made on 3rd February 21, neither us nor our clients have received any order of such hearing, which was reserved by you. We humbly request you to send us a copy of the order dated 21st January 2021. Upon perusal of the said order and only after the COVID situation was being under control, we would request you to fix a date. Now, this is the order which is page 413. So, this order was not even made available to us. And we write to them, this order is made available to us only thereafter. And the matter taken up on the 19th of April. After seeing the order, we find that these reports are required. So, this was a case where we were taken completely by surprise so far as this matter is concerned. Hearing on 19. Now, Lordship kindly comes. ना 19 All India Reporter 1998 Allahabad, page 346.
Thank you.
Paragraph 17. Oh, competent authority. জানো না মাঝে মাঝে অ্যাপিয়ার করে কম্পিটেন্ট অথরিটির জন্য Paragraph 17 is the whereas in the present case, last page, whereas in the present case, paragraph 17.
Clean hand.
Worship, the last 7 lines of paragraph 17, the last 7 lines. On the other hand, in the present case, it appears from the records that 18th April 96 was not the date fixed for disposal of the appeal. Therefore, the court has no jurisdiction to dismiss the appeal in default on the said date. Thus, this order suffers from other absence of jurisdiction to dismiss the appeal on the date not fixed for disposal of the appeal, a perversity implicit in the order itself. Therefore, in the peculiar facts of the case, the same is wholly distributed on the Harishananda. Oh, I actually meant Harishananda. Another judgment is not reported of Justice Standard as a paragraph 5 of this.
Standard.
Paragraph 5. The aforesaid order cannot be sustained for the simple reason that when the court has not fixed the date of hearing of the said application, it is not justified that the said application should be taken up on that date and be disposed of. Secondly, the court should not proceed to decide the application on the said date when the court has no occasion to hear the applicant on the merit thereof.
Fixed on that.
Lordship, last judgment on this is Justice Boshak's judgment.
This is already there.
This is Boshak's one page.
So, বড় judgment দিয়েছে তো বড় judgment
Paragraph 2. The learned advocate for the petition submits that the impute order was passed on a date which was not fixed for the date of hearing of the revision lab, and as such, the petitioner could not be represented. The government pleader appearing on behalf of the respondent authority is not in a position to produce any material to suggest that the revision application was taken up for hearing on a date fixed for such purpose. It should be appropriate to set aside the order in view of the fact that the impute order was passed on a date which was not fixed for hearing. Here, coming back to my the point that this was not the date fixed for hearing. Fixed for hearing would be, as the court said, after these reports come. On getting written statement for page 414, on getting written statements from ISAP and report from the CA Barrack 4 and ULC branch under the UD and MA department, the matter would be heard again. It's the last line of page 414. On getting written statement from ISAP and report from CA, and the matter would be heard again. And that is from page 431, it would be evident both were outside. When the court said that, and this order was also made available to us very last.
You were present when the matter was taken up on the.
Yes. Yes, because we get a notice on 16th April that the matter will be, that is page 412, I get a notice on 16th April that the matter would be heard on 19th April. Well, I write back on 16th itself at the 21st January, the 21st January order is not yet available to me. Plus COVID, so kindly don't take it up on 19th. But the matter is taken up on the 19th. On that day, we once again objected that because by that time we had got the 21st April, 21st January order. We pointed out this fact as would be, in fact, we had given a note of argument where we were specifically, we pointed out this fact that the matter could not have been fixed, couldn't have been heard on that day because the reports were, because 414 last 3 lines of page 1. This we pointed out, we wanted. But I am stressing on 414 last 3 lines.
Yes.
Now, Mala, I have to come to their best point, Justice Boshak's judgment in the section 4C. My Lord has got the copy of the order.
Yes.
It kindly comes to page 24.
Page?
24.
Yes.
The other, para 49. The other aspect with regard to the so-called violation of the provisions of the Act of 1976 has been held by the tribunal not to be within its jurisdiction, and rightly so. In any event, the writ petitioner has not been successful with regard to the challenge thrown under the Act of 1976, also before the appropriate authority. This is the challenge which is now a continuation of the tribunal proceeding. Now, Lordship, kindly come to paragraph 51, urban land sealing. The ratio of LK Ratna has no, this is not on the ULC point. This was on the point of natural justice has to be followed both by the trial court and the appeal. What starts really from paragraph 52. Paschim Bongo Bhumijibi, 52 is still pending in appeal. Now, paragraph 53 are the 53, 54, the specific ULC cases cited by us. Paragraph 53. P.S. Rao has held that an application for grant of exemption under section 20 of the Act of 76 is maintainable even after excess land has been declared and such land has vested in the state under section 10. Dorothy Clare Pereira and others has also dealt with the provisions of the Act of 76. It has observed that under the scheme of the Act of 76, on publication of notification under section 10(3), and after putting a date from which the land stands vested in the state, and after publication of the notification in the Gazette, and on and from the date mentioned therein, the excess land stands vested in the state, free from all encumbrances, subject to decision in appeal, if any, failing of any according to law. This is in the context of section 20. Then paragraph 25, 55. Well-wisher Electronics has dealt with the provisions of the Act of 76 in the context of an order of the competent authority withdrawing the exemption under section 20. Now 56. Propriety of order granting conversion under the Act of 55 has been assayed. Infractions, if any, of the Act of 76 is not the subject matter of the present proceeding. And the tribunal has correctly held that the same is outside the purview of its jurisdiction. Consequently, authorities cited on the subject of alleged infraction of the provisions of 76 Act have no manner of application. Well, my submission is that Act of the ULC issues why I have a locus under the Urban Land Ceiling Act proceedings and why the Urban Land Ceiling Act order is wrong and what are the peculiarities of the law was not, and it was expressly kept outside the purview of the Section 4C proceeding. Now, my lord, I will, since your lordship had put to my junior on locus standi, that if I have nothing on locus standi, then lordship will not unnecessarily remit the matter back because it will be wastage of the court's time, which I can very well perceive. Well, so far as ULC is concerned, well, the basis of my submission, I will support with authorities just now, is that Section 20 exemption is granted only after the land is found to be in excess. They joined the issue on that scope, but the court did not decide. The court has the courts have held Supreme Court up to Supreme Court, and only after it has been determined that land is excess can there be a Section 20 exemption. What follows from that is that vested land, the land is an excess vacant land under the Urban Land Ceiling. And by virtue of the provisions of that act, with effect from 76, it automatically vests in the state. Once it is determined that 20,000 here, 20,000 odd square meters is excess vacant land, it automatically vests in the state. So it becomes a state's property. If it's a state's property, then in that case, there's a scheme under the Urban Land Ceiling Act, which is framed, which says excess vacant land, how to be dealt with. Well, here, once the Section 20 exemption goes, the right to retain the land is also gone because Section 20 exemption does not take away the vesting, but it merely allows the exemption holder to hold the land and to use it in terms of the exemption. If it is not followed, the terms are not followed, then the law is, I will try to endeavor to show is that automatically the vesting revives. And the cancellation of the exemption order, very many cases have been held to be not justiciable. Because you are holding at the whims of the state, at the discretion of the state on certain conditions. If admittedly those are not fulfilled, then it goes back to the state. So then it becomes excess vacant land where other adjoining, the nearby industry
Can step in.
Well,
The petitioner can step in. Enjoy the consequences. That is your case.
that is my case. I will show from the scheme that I have a. Okay, হেসেছে বলছে ঠিক আছে. So excess vacant land. So I have a right then to apply to the government that if it's not used, because as per priority, first priority gets hospitals and parks and things like that. Otherwise, I have a right to get the land for industrial purposes, for which it is, for which it was allowed to be exempted. And in such a situation, I will also show, my lord, that locus standi will not be a factor even in a private petition. Leave aside public interest, because public interest or public interest, the private petition of an adjoining neighboring land can always come and say that this is government property, and if it's a government property and is not being used as per the diktats of the government, then any neighboring owner can come and object. Like this happens most often in municipal laws.
Where do you derive the right from? Any provision?
Whether
Where do you derive this right from? Any provision?
My locus to object. My locus to object, there is no provision. But it is a man-made law. It is a judge-made law. Judge-made law. But on locus, well, Lordship will see under Article 226, there is no provision. Anybody in any matter. It is person aggrieved. Person aggrieved, that is how we have normally. There is no provision, unlike.
Is the petitioner a person aggrieved at the moment?
Malad, that is what I will show, Malad. For when, say for example, when I am staying in my house, wherever, I see 20 meters away a government land, or 100 meters away, 200 meters away, government land being utilized for a purpose not for which it is not sanctioned. Can I come in a private rate petition? That is the question. But that, fortunately for my client, and I will endeavor to satisfy my lord, has been considered by the courts on various occasions, and the courts have held that in such a situation, even though there is no provision, but a writ petition can be filed. Petition can be filed. Can be filed, and on locus standi ground, it can't be rejected. Because if we can show that there is an infraction of a law.
Are you relying on authorities? I think I should release the other matters for the day.
Yes. For the first time.
First half matter will be released for the day.
In the first half, other matter released except item 13.
Well, may I start with pure locus standi, and then I shall come to the ULC specific. What is the 2000 Volume 7 Supreme Court, page 552. Thousand volumes 7 SCC 55. Paragraph 12, 13 and 14.
Paragraphs 12, 13 and 14.
Page 557. In this context, we notice that this court has changed from the earlier strict interpretation regarding locus standi as adopted in Nagar, Rice and Flour Mills and Jasbai Motibai. And a much wider canvas has been adopted in later years regarding a person's entitlement to move the High Court involving writ jurisdiction. A four-judge bench in Jasbai Motibai pointed out for the three categories of persons vis-a-vis locus standi. A person aggrieved, a stranger, and a busybody or a meddlesome interloper. Learned judges in that decision pointed out that anyone belonging to third category is easily distinguishable, and such person interferes in things which do not concern him, and he masquerades to be a crusader of justice. The judge has cautioned that the High Court should do well to reject the petitions of such busybody at the threshold itself. Then their lordships observed the following. The distinction between the first and second categories of the applicants, though real, is not always well demarcated. The first category has, as it were, two concentric zones, a solid central zone of certainty and a grey outer circle of lessening certainty in a sliding centrifugal scale and an outermost nebulous fringe of uncertainty. Sounds like Sir Winston Churchill. Applicants falling within the central zone are those whose legal rights have been infringed. Such applicants undoubtedly stand in the category of persons aggrieved. In the grey outer circle of the bounds which separate the first category from the second intermix, interfuse, and overlap increasingly in the centrifugal direction. All persons in this category may not be persons aggrieved. A recent decision delivered by two-judge bench in Chairman Railway Board with Chandrima Das, after making a survey of the later decision, held us. In the context of public litigation, however, the court in its various judgments has given the widest amplitude and meaning to the concept of locus standi. I'm not troubling with public interest. Paragraph 14. Paragraph 14. In the light of the expanded concept of the locus standi, and also in view of the finding of the division bench of the High Court, that the order of excise commissioner was passed in violation of law. We do not wish to nip the petition in motion solely on the ground of locus standi. If the excise commissioner has no authority to permit a liquor shop owner to move out of the range and have his business in another range, it would be improper to allow such an order to remain alive and operative on the sole ground the person who filed the petition has strictly no locus standi. So we proceed to consider on merits. But here, my lord, I will be just reminding my lord of the findings at page 431, where the appellate authority has categorically noted 431, third paragraph, that there has been infraction of the section 20 ULC exemption. And show cause has been given to the issued to the SAB or whoever is the exemption holder. This is, I'm just reading out from page 431. After that, to reject mine on the ground of locus standi is not called for. Page 431, third paragraph. In response to the allegations made by the appellant that ISAB has violated the provisions of the ULC of the order of 29th October 1992, that's section 20. The ULC authorities inform that since no such proposal for change of business purpose or initiation of new project was received from ISAB, and it was reported that ISAB has stopped functioning since 2015. One notice dated so and so was issued by the authority concerned to the said company asking to show cause for non-compliance of the order. And ISAB has duly submitted reply which is under scrutiny of the ULC authority. As in the appeal petition received on 18th, the appellant counters and the ISAB that are you now. So to get out of the exemption, their stand is altered. They are saying the section 20 was not required at all. There was no excess vacant land, which so their predecessor wrongly got the. So they admit section 20 violation, but they're justifying by saying that it is not required. So 20, so long as it remains there. So that's why in that context I am citing this judgment when illegality is apparent. And Lordship will also find from the next page of the order, page 432, Roman 3. The third, fourth, fifth line of that Roman 3. Or I can read it. The matter of grievance or displeasure or concern that leads the appellant to file petition under 33 is not established. Flouting of order in 29th October 92 if occurred is entirely related to ISAB in the limited for which the concerned authority has already initiated action. So the order is being flouted, that's already on action is taken. So it cannot be said that there is no illegality found. There is illegality found, but I have been shut off in that we will deal with it internally. You are a nobody. That is what, where in a similar case, when the violation of law is there, The court should the court should probe into it, see what action is taken. If I have initiated the motion, I can't be shut up by saying that you have no locus standi. And the court's purview is gone from the court's purview. Vrinda, that is why the
Authority has already taken action, is it?
but that's the ULC authority. That's what they are saying. So,
And that's a different aspect altogether between the authority and the
and authority is safe. So, but here, like in this case, if I coming back to relate to this case, where it is shown that there was an illegality.
Yes.
One thing for the High Court to say that the authority is taking action. But the High Court will it shut its eye whether appropriate action is taken or not. But you kindly see the facts of this page, the 2000 volume 7 paragraph of this judgment, paragraph 2. A bidder in action for the privilege of vending foreign liquor within a circumscribed range was permitted by the excise commissioner to have his domain shifted to another day. On hearing the said news, a hotelier who was doing business in the latter range was distressed, and she quickly approached the High Court for thwarting the said. The first round, the hotelier failed to checkmate the bidder. A single judge declined to grant it. Second round, successful. In this case, who is there to monitor whether action is being taken to its logical conclusion? Whether action is being taken to logical conclusion or not. But that is what I'm here. When there is an infraction happen, and the authority has noted that action is being taken. Now, I am telling the authority, please see whether action is properly taken or not. Like, for example, in the next court order, when unauthorized construction is there, and the petition is moved by a stranger, that property is unauthorized construction, and the corporation comes and says, no, we are taking action. Will the court then say, when the corporation is saying that they are taking action, I will shut you up? No. The courts then see at the petitioner's instance whether action is being taken in accordance with law. That is what the writ petition is for. Otherwise, every writ petition can be shut off by the authority by saying that we are taking action. That is where I step in to show that. Well, another judgment on this proposition is 2000 hours down. 5 cases, 5 cases. 2005, volume 3 Supreme Court cases, 6-8. Page 68, page 683. Paragraph. The main grievance of the appellant before the High Court was that the Prakash Palace video parlor, respond number 3, was situated within 350 meters from Shai Chalchitro, and hence no license could be granted to respond number 3 to run a video parlor under the UP cinema regulation. It was also asserted that the exhibition of video films by respondent number 3 had badly affected the cinema business of the appellant. That was the real reason. As the video parlor was situated very close to the cinema hall. It is also submitted that the grant of license in respondent number 3 was in violation of provision. Now, paragraph 4. The learned single judge before whom the writ petition came up for hearing dismissed the writ petition on the locus standi of the appellant to file a writ petition without going into argument. It was observed that the appellant could not raise a grievance against his rival in the trade, particularly when the rival in trade was in the instant case exhibiting cinematograph film much before the appellant was granted the license. It was held that the appellant had not been denied or deprived of its legal right to exhibit the film and therefore he had not sustained any legally protected interest. It was also observed by the appellant that the appellant had not suffered any legal wrong, petition, the help to be not maintained. After hearing the counsel for the party, we are of the opinion that the High Court clearly erred in dismissing the writ petition filed by the appellant on the ground of local standard. The appellant being in the same trade, I was same trade, he's the industry, being in the same trade as respondent number 3, the right to seek the cancellation of license granted to respondent number 3, being violation of the act and the rules. For the reasons in the above, the administration is admitted back. Well, as I am coming back to here, whether the authority has then ULC authority has told the appellate authority we are taking action. But whether action has been taken, it appears not. Otherwise, ULC will not be coming through. Mr. Aniruddha Chatterjee, who's not doing another matter in the Chief Justice's court, and sitting here devoting all his time and attention. That shows that the ULC's authority is not taking the action, and I am not at the appellate authority.
That shows.
So he has to be, by name, he should be party in the proceeding, by name.
Mr. Chatterjee's
Yes.
action shows.
So he has to be the party in the proceeding.
My lawyer, he can act on my behalf.
We are together in a matter with Honorable Chief Justice, and he is giving
No,
this.
he's not sitting
Not sitting here.
Hey, my Chief Justice আমাদের বারে আসবে চল বল বেটা
I'll take 15 minutes maximum next.
So you'll take some.
15 minutes.
ওই দেখো
Next, you can.
Monday.
Any day lordship, I would maintain that.
এখন না রিভিশন
For the consideration on.
একটাও নেই
হ্যাঁ আমারটা নিয়েছে একটা
তুমি তো
আমি মেনশন করি কি পরেটা কি বলবো না থাক না বলে দিবি
করিয়ে নেবেন শেষ হয়ে
Contempt application group 7, 561.
My lord, 561 to 566 appearing for the first time.
Serve and come back then.
My lord.
The applicant, huh?
ব্যাপারে বয়স আসছে না কেন?
5th February.
My lord.
561 to
566.
তুলে নেন।
My lord, may I have your lordship's leave?
5th February.
This matter, my lord, I have instructions to appear for the private respondent number 4, my lord. And moreover, my lord, one
They play how you know? Nice. Normal.
567.
Well, I am for the British number. My lord, I have instructions to appear for the private respondent number 4, my lord. But my lord, difficulty is one more writ petition is pending. He's flying the vehicle.
May I address?
Flying the vehicle without the timetable, my lord. Timetable has lapsed, my lord. And he's still flying the vehicle.
This is not your spirit petition.
I have filed one writ petition, my lord. I have mentioned on the 17th of November before your lordship.
Maybe,
Here, my lord. Same issue.
When is it appearing?
My lord, I mentioned it on 17th of November.
When is it appearing? No date has been fixed.
No. I mentioned
Well, may I-
matter has not appeared, my lord. Same matter.
Well, may I-
issue, same party.
Well,
Kindly have a look at it.
I have been granted a permanent state gas permit by the regional transportation Purva Bardhaman. My lord, after the immediate grant of permit, my lord, I applied for approval of timetable. My lord, kindly come to page 21.
This present writ petition. 27609.
I'm sorry.
Yeah, I have made him party.
This one, kindly. My lord, no notice has been served for the matter.
In this matter.
No, automatic it's a automatic, it's a court procedure.
It's appearing in the monthly days.
The matter before your lordship on the same issue. Let this both be decided.
No, why?
Because my lord, he is not coming with clean hands, my lord.
You
He's flying
place
the
your
vehicle.
case here now. You
He's
place
flying
your
the
case.
vehicle without any permit, my lord.
You
The
place your-
application should be entertained, my lord. The timetable has lapsed 2 months before, my lord. He's still flying the vehicle.
Mala, may
I have lodged complaints with the SP,
What
the
is the
motor vehicle
prayer in
inspector.
this writ petition?
Mala, I have been granted
In your writ petition, you have lodged a complaint here.
Yes, against the flying of
timetable.
the vehicle illegally without any timetable
Mala,
for the last 2 months.
Mala,
And what is the prayer in the present writ petition?
Mala, I have prayed for, I have been granted permit. Mala, I proposed a timetable. The Regional Transport Authority invited objections regarding the proposed timetable and indicating within 30 days you have to make submission, you have to make your objections. But that is noticed that 29th September. But no objection was filed. My client has been awarded the grant of provisional timetable. That was extended, my lord, up to my lord, kindly come to my lord for 1 month it was granted. That is 8th of September, 1 month it was granted. No timetable, no objection has been filed. My client applied for extension of the validity of the timetable that is pending. I am praying, my lord, let them extend my timetable. If any objection has been filed, let the authority decide the objection. If any objection is filed in terms of the notice, kindly come to my lord, page 21. The notice, kindly the third paragraph.
This is the provisional timetable. page
Yes.
21.
And short for objection, my lord. Claim an objection, if any, within this period will be heard. Third line, my lord. Your lordship, kindly see. If my lord says he has made an objection, let him prove.
This is 2022.
Yes. Matlab 29th September 2023. Matlab next, my lord. Page 24.
Page 24.
23, my lord.
23, yes.
23. ভুল করেছে ওগুলো মানে 22 মানে ये लॉस से kindly 22 have a glance my lord. Twenty-two, 23, my lord.
22 is 11th October
Yes,
2023.
23. Next matter, my lord. This is my lord. 8th of September. Objection, suggestion, news, opinion are invited within 30 days from date of issue of this notice. Kindly see, my lord. My lord, page 23. Unless a P4.
Page 23 is of September 2023.
28th of September.
And page 22 is of October.
That is my lord mistake. That is a mistake, my lord.
Pratham
Good, yes.
word one.
This is my lord, the page 23. This is relevant, my lord. Eighth of September, my lord. Objection, suggestion, views, opinion are invited within 30 days from date of issue of this notice. If my relevant client has submitted objection, let the objection be decided. I have no objection. But my timetable will be extended. I have been granted permanent stretch my permit. I placed BS6 vehicle.
Revised timetable has been issued on 11th October 2023.
Yes, ma'am.
Page 22.
Yes, ma'am. That is also, my lord, 30 days only.
That is 30 days.
Very well. That is, I pay for extension of timetable, man. If my landlord file an objection, his client has submitted objection, let the objection be decided.
Where is your permit?
My permit, I have annexed my. Man, kindly come to page 19. It starts from 18, my lord.
It's valid till 2027.
7. Permanent permit, man, 5 years valid, man.
Now you can make your submission.
My lord, this timetable was passed for provisionally for a period of 30 days.
Yes.
During the vacation through the back door, and the officer who passed the timetable has retired. He has been transferred to another office, my lord. Without any kind of, my lord, inviting any kind of objection, this was issued. I challenged it before the bench of the Honorable Justice Raja Bosu Chaudhary. Matter was taken up in the vacation bench, but because of the difficulty, matter could not be taken up on that day.
Matter was adjourned to the regular court. I mentioned before your lordship on the 17th of November. Matter has not been listed. Moreover, there is an order of the division bench. He preferred an appeal before the division bench, my lord. Earlier, there is a specific direction that he should submit a fresh timetable, cash-free timetable. And his timetable is clashing with my timetable, my lord. And I should be given opportunity of hearing. I was not given any opportunity.
You will be given an opportunity of
That
hearing
is there.
before extension, okay? Mr. Devra?
Let him file an objection, my lord, first of all. He has to file an objection.
File an objection before the authority.
Because of the pendency of the petition.
It doesn't preclude you from filing an objection.
Yes, I have filed several objections, my lord. Let those be considered.
If any objection is filed, my lord, your lordship kindly know.
Objection of any person, everything.
Any person, my lord. Yes, yes, my lord. In response to that notice, my lord.
Is contended on behalf of the petitioner that the petitioner is a permanent stage carriage permit holder Puraton ground Nawabhat, Burdwan, and the permit is valid up to 29th September 2027. Provisional timetable was granted in favor of the petitioner by the authority, which was extended from time to time subject to objection, comma, if any, comma,
ওটা ঠিক আছে, এটাও ঠিক আছে, এমনি ঠিক আছে, ঠিক আছে।
submitted by other operators.
এটাও ঠিক আছে।
Paragraph. Learned counsel for the petitioner submits that the provisional timetable was lastly extended for a period of 30 days with effect from 11th October 2023. The petitioner seeks extension of the timetable till expiry of the permit. Paragraph. Learned counsel for the private respondent submits that several objections filed by the private respondent before the concerned authority against issuance of provisional timetable in favor of the petitioner has not been taken into consideration
Flying of the vehicle without my
by the authority
without timetable is flying the vehicle. In violation of section 66, my lord, condition of permit.
The learned counsel
For the last 2 months.
submits that the petitioner has been plying the vehicle without a valid permit.
My lord, timetable. Sorry.
No, without a valid timetable.
Permit is valid.
Timetable. Paragraph. Learned counsel for the state respondents submits that who should consider? Secretary. The third respondent be directed to consider the petitioner's request for extension of the timetable upon taking into consideration objections, comma, if any, comma, submitted by the private respondent and other operators. Paragraph. In view of the above, the petition is disposed of directing the third respondent to consider the request of the petitioner for extension of the provisional timetable till the period of validity of the permit upon granting reasonable opportunity of hearing to all concerned, including the petitioner and other persons who may have submitted objections against the said timetable before the authority. So the entire exercise shall be completed within 1 month. Within 1 month from the date of communication of this order.
One more thing, my lord.
My lord.
To put in a fresh timetable.
No.
That has expired last
The authority will decide.
My lord.
I have recorded the date.
Direction of the division bench, my lord. He should submit a fresh timetable without clash.
Have an opportunity before the authority. You can place that before the authority. Disposed of it. One matter today. Only one group civil matter. All the hearing matters.
568.
My lord, in this matter, I am representing the writ petitioner.
Yes.
I have received the opposition from the state. We need to file the reply against it.
Who is appearing for the state? You are appearing? No, KMD. What about the state?
No, there is two parties actually. One is the state of West Bengal and there is KMDA.
KMD has used their objection.
Yes, KMDA has not yet filed their no, they have not filed their opposition.
File any opposition? No. Yes? Have you filed? It is still in your brief. Please make over a copy. The state's opposition has also not been filed.
KMD has not filed the opposition.
State has also not filed.
The state has served me the copy only.
Not filed. Who is appearing for the state? Did it appear in the monthly list of February?
My lord, this is an old matter. It's been delayed because the urgency is lying with me.
Not there.
My lord, kindly fix it in.
Yes, are you ready with your affidavit today?
She is not well acquainted.
Where
She
is
is
your
not well
affidavit in
acquainted.
opposition,
Probably.
madam?
Probably she is not well acquainted.
It's not on record.
My lord, kindly fix it any particular day, my lord. Or in the monthly list also, it's not.
Monthly list of February. Affidavits are yet to be, none appears for the state respondents. Affidavits are yet to be filed. Paragraph, let the matter appear under the same heading in the monthly list of February 2024. Please exchange your affidavits in the meantime. It's a 2017 matter.
Take your
569. 569.
Not today.
571.
569 and 570, Mr. Rahul Kormakar is leading in this matter for the petitioner, Lordship. Just praying for Passover, Lordship.
Passover is not possible in this.
Lordship.
Then the matter?
Lordship.
On prayer of the petitioner, Rajiv. On prayer of the petitioner, the matter is urgent. 569.
569, 570.
Paragraph, let the matter appear under the same heading on 12th February.
Lordship.
$571.
Anyone? 571. None appears for the parties. Let the matter appear under the same heading in the monthly list of February 2024.
571. 572.
Same order. Same order, monthly list of February. None appears for the parties.
573.
I have
Yes.
Mr. Gautam Kumar Das is appearing for the petitioner. I'm praying for an adjournment for 2 weeks. The petitioner has expired. We need to take necessary steps.
It is submitted on behalf of the petitioner that the petitioner has expired. Stop. Learned counsel for the petitioner seeks to take necessary steps in this regard. Paragraph. It's the sole petitioner. How many petitioners are there? Only one? Right. Sole petitioner. Paragraph. Let the matter go out of list for the time being. You have to file a substitution petition.
574. My lord, I was been requested by Amit Kumar Pan. He was come.
Affidavits complete.
Yes, I understand.
Mr. Das for the NHAI, Mr.
Yes.
Siddiqui for the state, I do not find any. Affidavits are not signed.
But I have been served with the affidavit by way of an opposition, my lord, by the National Highway Authority.
On today.
When you fix up another deadline, I will serve notice to them.
Monthly list of February, Mr. Das is there. State, Mr. Siddiqui. Monthly list of February, please serve in.
Monthly list, my lord, instead of monthly.
Affidavits are not exchanged.
I for the National Highway
Where
Authority.
is your affidavit in opposition?
Fine.
Number 3. Your affidavit is on record. State has not.
Possibly they will not use an affidavit because this is the land, my lord, that has been forcibly dispossessed by the National Highway Authority only. That my whole allegations against the National Highway Authority.
So in that case, let
And-
me fix a date. Because
kindly,
private respondents are also
yes,
there.
my lord, kindly fix up a date, my lord, so that I can serve notice to.
And
Oh.
private respondents are there.
No, there is no, I do not find any private respondent, my lord.
Oh, these are petitioners.
Yes.
Oh, many petitioners.
Yes, yes.
Right. Please inform the state. Mr. Siddiqui
Fine.
is appearing.
I will.
Appears for the state respondents. Paragraph. Do you intend to use a reply? No.
No, yes, my lord, if I find my lord, I will file the reply in the meantime.
Learned counsel for the petitioner seeks to use an affidavit in reply to the affidavit in opposition submitted on behalf of the National Highways Authority of India. Paragraph, let the matter appear under the same heading on 19th February.
Bless you. Bless you. Yeah, program recorder nahi, क्यों আসবে না?
575.
I am for the petitioner, madam. My lord, similar situation.
Madam, my lord, I am for the statement. So, my lord, I filed the HON'BLE
Affidavit.
in opposition, my lord.
Yes.
But now, my lord, in another case, previously, my lord, I am not in this case, my lord, but after that, I am. Previously, to what election was done, but after that, nothing was done. But the land, some portion of the land was in the occupation of the PWD. So, my lord,
Light of this.
Your lordship was pleased to pass that order.
Yes.
Next one. Portion which is utilized.
You want to purchase?
That is the one of 4 I will consider the representation, my lord, in the light of that, my lord. After that, we will consider up to the those portions.
Utilized portion.
Utilize.
And
Rest of the.
the rest of the.
Sorry.
The rest of the land, my lord,
Release.
Not release, my lord, they are not. Yes, well, one order is.
The unutilized portion.
Yeah, my lord.
There is a representation pending.
No, my lord, he must file a, his representation not a benefit.
Filed within, my lord, dependent will be made submitted before the authority by 4 weeks, my lord, and the authority can consider our representation, my lord. Kindly time frame should be, my
Yes.
time.
It is submitted on her learned counsels for the parties. Paragraph, it is submitted on behalf of the petitioner that the land of the petitioner was requisitioned under section 3 of the West Bengal within bracket requisition and acquisition bracket closed Act 1948.
And that was 1975-77.
The LA case.
That is the requisition. LA case number was not in our exhibit, my lord, nothing was there.
Oh, in connection with Act Roman 2 case number 75 of 1977-78.
Yes, ma'am.
With Act Roman 2, capital 2, case number 75 of 1977-78. Stop. The process of acquisition was not completed. Was not completed, for which no compensation was paid to the petitioner by the authority. Stop. A portion of the land has already been utilized by the authority, by the PWD, by the Public Works Department. The petitioner seeks to submit a representation before the concerned authority ventilating his grievance. Petitioners, ventilating their grievance and prays for a direction upon the authority to either to release the unutilized portion of the land in favor of the petitioner and
My lord, divided the utilized portion of the land.
yes, and take necessary steps for acquisition / purchase of the utilized portion upon demarcation of the same. It has to be either acquired or purchased.
Yes.
Paragraph, learned counsel for the respondents submits that the fourth respondent.
Yes, madam.
That the fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the fourth with liberty to the petitioner, directed with liberty to the petitioner to submit a comprehensive representation before the fourth respondent within 4 weeks. Within 4 weeks from the date, stop. The fourth respondent is directed to consider and dispose of the representation within 2 months from the date of receipt there. Upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law.
Acquisition or direct purchase?
Direct purchase by the earlier order, my lord.
Acquisition or direct?
I am leaving it open to the authority.
My lord.
Not giving any direct.
My lord, last order, my lord, your lord, past order, my lord, the acquisition, purchase the direct, my lord, the notification, according to notification, my lord. There is an indication, my lord.
It's under the 2013 Act. Why should I narrow your scope?
That
My
is
lord, otherwise, my lord, that's because my lord, there is no contract for the subsection.
my lord, that should be linger, my lord. That's fine.
My lord, acquisition or acquire or.
I do not want to make any observation.
Yes, ma'am.
I have just recorded the petitioner's submission.
Yes, ma'am.
And let the representation be considered. You file a comprehensive representation.
Yes, ma'am.
I do not want to narrow down the scope of the authority
Yes, ma'am.
or the petitioner, right? If the court says something, the authority will not go beyond that.
Yes, ma'am.
Right? Within 2 months, madam, from that, in accordance upon here. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Hearing matter.
My lord, may I submit one thing, my lord?
Yes.
In last paragraph, first page, my lord, that should be indicated, otherwise, my lord.
That is your submission. I have recorded your submission.
Last paragraph of the first page, my lord.
In that case, my lord, we purchase the.
The state is willing to purchase. I'll record it.
My lord, same road, my lord, same area, my lord.
যেখানে state submission. It is learned counsel for the submits. এটা প্রথমে দিন তারপরে representationটা দিন learned counsel submits that the state is willing to purchase the portion of the land utilized by the authority and release the remaining portion of the land which is not utilized.
Five 76.
576. None appears for the parties. Let the matter appear under the same heading in the monthly list of February 2022. 24.
577.
Lord, 577, I beg to appear on behalf of the petitioner, Lordship. Lord, in this matter, my Lord, the petitioner is one of the land losers, my Lord, who, my Lord, filed their objection, my Lord, at the time of hearing. But in spite of, my Lord, that, my Lord, his objection was not considered. My Lord, neither he was, my Lord, awarded with the money, compensatory money, my Lord, he was, my Lord, willing to, my Lord, take back
I
his
think you have
land.
to serve a fresh notice because the earlier
Yes, my Lord,
application
he
is
has
no
been.
longer in the panel.
My Lord, only, my Lord, may I beseech your Lordship, my Lord, I have prepared a supplementary affidavit. If that be taken on record, my Lord, I'll.
File that, but
Lord.
serve a fresh notice
My
upon the
Lord.
GP's office.
My Lord.
Because Mr. Sengupta and Mr. Shadhu, they are no
Yes,
longer.
my Lord. My Lord.
You're filing the supplementary affidavit?
My Lord, may I file, my Lord?
Yes, supplementary affidavit filed on behalf of the petitioner is taken on record. Paragraph, since there has been a change of learned counsels in the state panel, the petitioner is directed to serve the office of the learned government pleader afresh and file affidavit of service on the adjourned date. Paragraph, let the matter appear. Affidavits are exchanged.
My Lord, affidavits already exchanged.
Already exchanged.
Already exchanged.
Paragraph, let the matter appear under the same heading on 21st February.
My Lord, may I seek, my Lord, I know, my Lord, your Lordship's pressure, my Lord. May I seek some early date, my Lord, if your Lordship so desires, my Lord.
Matter. January, it's full.
Grateful.
Come back, serve and come back. They need to take preparations also.
Grateful.
578.
I'm for petitioner. I'm seeking for accommodation, my lord.
Affidavits complete.
Complete, my lord, because I am not with the file. My lord, I was at South India for treatment purpose, my lord.
Who is appearing for the respondent?
My lord, Mr. Tale Masud Siddiqui, my lord.
None appears for the respondents. We will stop on prayer of the petitioner. The matter is adjourned. Paragraph, let the matter appear under the same heading on 21st February.
21st February.
February. Please inform.
Yes, definitely. No, my check up the file because the file is not received. I'm grateful.
Next, 21st February. Yeah.
579.
Well, there was a last occasion, my lord, directed to file affidavit. 2 years back, also directed file affidavit. No. Well, this is a very short question. How can a date? How can when a will has been made, subsequently after the death of a person, another will can be made?
How does this court have determination?
Yes, yes, land matter. Because the court, on the basis of a subsequent compromise, the Urban Development Department mutated his name. Till last 200 years.
Challenging the will.
No, I am the beneficiary of the will. Subsequently, another person came. The before this will, another will, subsequent another will executed by somebody. So therefore, he is also entitled to the half of the share of the Salt Lake property. In Salt Lake, one knows that there is the leasehold property. Even there is a division bench judgment of this court, and ultimately, in the 2021 Supreme Court said that if there is a bar in making a will, one cannot make any will. Even assuming that party, one can.
Not primarily challenging the will.
Mutation. No, mutation. When there is a will already granted probate, after that, how can there be another compromise?
I do not find anyone for the respondents today. Could you please inform them the next day?
Next. But notice, after notice mention was there. But except 22, there is the case fixed in Supreme Court, so up to next Monday, 22, except 22, any other day, my lord.
Are they still in the panel, Mr. Amitesh Banerjee and Mr. Ado?
Yes, Amitav Banerjee is definitely in the panel.
They are in the panel? Mr. Where are they? I'll fix a date. Please inform them about the next.
This is a very, there is a reason for avoiding this case because.
Thank you. Affidavits are yet to be filed by the respondents. None appears for the respondents. Paragraph let the matter appear under the same heading on 12th February. 12th February.
Oh.
Please inform them.
Ma'am, no.
Five eighty.
580, my lord, I am for the petitioner, my lord. Affidavit are exchanged, my lord, already, but during pendency, my lord, the petitioner died. We have already filed a substitution application. Yes, yes. It is CAN 1 of 2023, my lord. Service is already done upon the respondents.
So let it appear as an application.
My lord, if my lord directed, I can intimate them that matter will be appear.
Yes, please do that. Let it appear under the heading application. Let that be disposed of. Within time.
My lord, during Corona, my lord, it is there.
You are covered by the Supreme Court judgment.
Yes, ma'am.
Okay.
But if necessary, my lord, I have filed section.
Have you served the other?
Yes, yes.
Bandyopadhyay is appearing.
Yes, Mr. Soumitra Bandyopadhyay and Priyabrata Bhattacharya appearing. My lord, I have served on them, and the respondent number 4, my lord, Sumir Kumar Chakraborty, I have also served upon.
Learned counsel for the petitioner submits that the petitioner has expired and a substitution application filed by the legal heirs petitioner is pending. Stop. None appears for the respondent. Paragraph. Paragraph, let the matter appear under the heading application on 22nd January.
22nd.
Please inform.
My lord. I will.
Can the name call? Can the hearing that on 22nd January? Next.
581.
81, my lord, in this matter, my lord, I am appearing for the petitioner,
State.
Mr. Bandyopadhyay.
State today, I do not find anyone. Affidavits are exchanged.
Reports.
This
No,
581. Lordship, I have filed my affidavit on the last occasion. It is recorded in the order dated 4th December. They have filed a report, Your Lordship.
there's an observation that matter needs to be heard on affidavits. Affidavits were called.
Yeah.
The last time the probably state was invited the court to pass and that they want to file.
Copy.
Which one?
This is the date when I said check.
Copy আছে কি আমার? আমি দেখতে পাচ্ছি না হ্যাঁ দিয়েছো দাদা আমি বলছি না যে দাদা
Have you received a copy, Mr. Roy? State's affidavit, have you received?
No, well,
Yes, time for it.
this is a copy of this.
This is NHI.
It is a copy I have received.
Now.
Yes, sir.
Learned advocate for the state respondents seeks extension of time to submit affidavit in opposition as called for.
Yes.
Paragraph affidavit in opposition be filed within 2 weeks from date. Stop affidavit in reply, comma, if any, comma, be filed within a week thereafter.
Yes.
A week
If at all, if any, my lord.
Monthly list of February.
After February, my lord, I am not on that. After February, any date, my lord, there's a, it can be supplementary list. That's, no. Monthly list of February means it will appear on the first working Monday of the month list. Any day after that, so that it can be listed in the subject. That is the prayer I can pray for your lordship.
Then the 13th. Let the matter appear under the same heading on 13th.
Obliged.
This is the only thing I can pray for.
Next.
Civil matters will be taken up from tomorrow at
3:30. Hundreds of civil matters.
always much less. Only 100.
13th February. More than 50, 60 mentionings were done today itself.
Much less, sir.
582.
2,500 matters.
Before this bench.
That is why it is only 50. Oh, today is the first day. Tomorrow onwards, my lord, 5.
But I am for the respondent.
During the pendency of this case, my respondent petition number 3 was died. Well, I made application for substitution.
But I am for the respondent number 5, my lord. Concerned municipal authority.
Others? Mr. Day is appearing for, where is Mr. Day?
They are
654.
Well, within time, there is no apartment, man. Within time manner, I filed the petition for substitution.
I'll give you a short date under the heading application. Have you
Well,
served? Have you served?
I have already
Yes,
served my announcement.
I got to, my lord, yesterday I got the copy, but I have no objection regarding my lord, the substitution.
Substitution?
State is there.
Yes. The state is the answering respondent, but the fact is that, my lord, the
Fact is very clear, my lord. That, my lord, the land was requisition acquisition notice was given. Subsequently, it was, my lord, withdrawn. Due to, my lord, the withdrawal of the, my lord, the Requisition Act. And, my lord, they are in position, municipality who are in position for a long time. That is 24 years. After 24 years, my lord, they are evicted by the court. My lord, I made application before the authority that during that time, I am entitled to have the compensation.
rent compensation.
Compensation, my lord, due to, my lord, occupation of the land. So, my lord, it has been inducted by the, my lord, the state of West Bengal to the municipality. And so that, my lord, I am entitled to have it. My lord, thereafter, my lord, the petition, I made petition that I have to, and I am entitled to get the compensation. They said no. Only one question there, we have not taken the position of the land.
Your application is also not on record.
Application, record nahi, kote ache. Application ta diye.
Let the
Yes,
matter
yes,
be
fix it.
along with the application. I'll give you a date, and please inform Mr. Day in the meantime.
Mile,
Then I can hear the petition itself.
mile. Monday, your lordship kindly take it up on Monday.
I'll see. Monday, not possible.
Uh,
Cat 1 of 2023 is not in the file. Department is directed to put up the application along with the file on the adjourned date. Paragraph none appears for the state respondents. Paragraph let the matter appear under the same heading. 29th January.
29 January.
I'll put both together, the substitution application as well as the writ petition.
My very short point, I am giving
That's
judgment.
the heading I have said.
Mile.
No, hearing is motion and hearing, same heading, hearing is. But please inform the state.
Mile.
Next.
583.
583. None appears for the parties. Let the matter appear under the same heading. The matter is February 2024.
They just want support.
584.
584. Same order.
585.
Same order.
586.
Same order.
587.
Same order.
588.
Same order.
589.
Same order.
Next one below. 590.
590, so I'm for the petitioner. Also, I prefer not today only. This.
Affidavit 16.
That's the affidavit exchange.
File your reply also. Adjourned on prayer of the petition on several occasions.
না মামলা করা আছে দরকার পাশেই
Report written notes of argument, Lordship, para filed.
It's a hearing matter.
Hearing matter. Yes, sir.
I do not find affidavits. It's only been adjourned day to day.
Hmm? 590.
Let it appear as a hearing matter. On prayer of the petitioner, the matter is adjourned. None appears for the respondents.
No, the London state has that.
Yeah, for the state?
Yes, my lord. Only state is there.
Evidence complete.
Yes, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same hearing on 21st February. There are others also. You have to please inform them. There is an intervening respondent.
Intervening respondent,
Please find out, Mr. Mukherjee.
Lots.
Yes, next.
State number. State. নামটা এই নামটা দিল ওই ডেট ফিক্স করে দিল আচ্ছা আমাদের বুকিং করছে বাতামের
590. 591.
591, I have instructions to appear on behalf of Indian Oil Corporation. We have used our affidavit.
Appearing on the petition. You received a reply.
Mr. Bhagavat Chaudhary Milan, affidavit in reply has also been served on us. We have received it on the 3rd of December 2021.
Right, it's on record. Any other respondent?
Well, I am for the respondent, Indian Oil Corporation. 2 and 4, 2 and 6.
Corporation is, that's all the response. 2 to 7, in fact.
We have used an affidavit on behalf of 2 and 6.
We fix a date for hearing.
And as your lordship pleases, Milan.
Will you please inform the petitioner? You're not supposed to, but still.
No,
Or let
yes,
it
yes.
appear in the monthly list of February because the petitioner.
No, we are 2, 3, 4, 5. No, competent authority. I'm not appear করছি। Competent authority appear করছি। 2, 3, 4, 6, and 7.
Not 5.
Not 5. My competent authority, I am not appearing.
It's also the Petroleum and Minerals.
But it is, it's under the Act, 1962 Act. And Union of India is respondent number 1.
Monthly list of February. Petitioner is not interested. None appears for the petitioners. No accommodation is sought. Paragraph, let the matter appear under the same heading in the monthly list of everyone.
Great.
Next.
592.
My lord, on behalf of Mrs. Jasmine Ara Khatun, my lord, I'm praying not this week, my lord. Not, yes, my lord.
Affidavits are exchanged.
My lord, I have not the lawyer, Mrs. Jasmine Ara Khatun for the petitioner, my lord. As a yield, my lord, on her behalf, praying 1 week time, my lord.
Affidavits are not exchanged. Monthly list of February. Affidavits are yet to be exchanged. Let the matter appear under the same heading in the monthly list of February 2024.
Yes, Marshal.
Next.
Item 521. Again,
593. 593.
None appears for the parties. Let the matter appear under the same heading in the monthly list of February 2024.
594.
I am on behalf of the petitioner, my lord. All affidavit are exchanged, my lord. Mr. Chondidas is the state. Let the matter 10 day after tomorrow,
Not possible.
Wednesday.
Have you filed a reply? Have you filed a reply? I do not find any affidavit on record.
None record. Filed.
Yes?
It's on the custody of our custody.
Opposition has not been filed. Monthly list of February.
Opposition? Opposition has already
Not
served,
been filed,
not
sir.
filed in the court.
Monthly list of February.
Extend.
Where is your reply?
Extend the matter. I think.
Where is your reply, sir?
Yes.
Where is it?
Yeah, I'm the reply filed.
None appears for the respondents. Let the affidavits are yet to be exchanged. Let the matter appear under the same heading in the monthly list of February 2024. You are not ready with your reply also.
Actually, in this appellate side, my lord, already exchange be done there. The day before the hearing side, deposit there, submit that. That is the point. So.
Next.
595. 595.
None appears for the parties. Let the matter appear under the same heading in the monthly list of February 2024.
596.
Same order.
597.
Same order.
598.
Same order.
599.
Same order.
600.
My lord, I am for the petitioner. My lord, in spite of service, on last occasion when this matter came before my lord Justice Talukdar, in spite of service, none appeared. Mr. Justice Talukdar served, we served the copy as per the direction, my lord, lordship, your lordship kindly, we have served the copy and the every service, both. Two every service are there. Till now, but given your lordship on 2nd of March 2020.
Who is Mr. Raja Shaha?
Raja Shah, we serve all of them.
Is he still in the panel?
No.
Yes.
No. No. No.
He to serve afresh on the GP's office.
My lord, this is only for my lord. In the meantime, they are going to construction the highway. We make a representation. Let them consider the representation only for.
Without the other side, without serving them?
We have served, my lord. Every service is there.
There has been a change of panel in the meantime. Have you served after that?
No.
You have to serve.
Then GP के सर्विस करो जी राजा साहब का आगे सर yes already service এখন তো চেঞ্জ হয়ে গেছে বলছে मतलब already we have served the GP government leader but then we will serve the notice मतलब that
After you serve the government leader, Mr. Shah was appointed.
yes
Now he's no longer in the panel.
my lord
You have to make a fresh service, isn't it?
then my lord I will serve.
Several private respondents.
We have every service is there my lord.
Where is the affidavit of service showing service on the private respondents?
দুটো দিয়েছে একটা কই এমনি সার্ভিস এই তো হ্যাঁ না স্যার
Where is the service upon the private respondents?
এটা কোথায়
আগের সার্ভিসটা কোথায়
আগের সার্ভিস
I request you to serve all of them and come back.
আগের সার্ভিস
मतलब may I go there? Earlier when you move before this my lord Mr. Talukdar already served the notice his lordship none appears on behalf of the in spite of every service
সার্ভিসের কপিটা করুন
আগের সার্ভিসের কপিটা নেই তো এখানে
দর্শকের কাছে আছে না
ফাইলটা আছে
None appears for the state respondents in spite of service. That is the recording in the order, not the private respondents.
সার্ভিসের কপিটা জানি না তো
See the second page of the order. None appears for the state respondents.
স্টেট কাউন্সিল
এভরি সার্ভিসের কপিটা দেখে দাও
এভরি সার্ভিস নেই এখানে কপিটা চেক ইট আপ
original video service your lordship's brief
Since the matter is waiting since 2019, why don't you make a fresh service and come back? The state you have to serve afresh.
my lord said I will serve but regarding the private respondent we have served my lord may
No endorsement in the record. This becomes a ground for appeal.
my lord the review service earlier we have filed in the court my lord that is
Yes, but it doesn't show
That-
service. Absent. This is again absent on one occasion. That is not service.
we have served my lord that every service private respondent we have served
There are certain track reports, but no postal receipt. You can check the record if you want to.
my lord may I just 1 minute একবার দেখি
but all postal receipts are there in the first page annex all postal receipts are there and one of the private respondent AD card received and other absent returned to sender the address available when it was sent and another AD card is also there
Absent is not service.
and another AD card is also there
yeah absent but this is, but track report is delivery location track report it's delivered
and all tracks reports are also
delivered my lord your lordship can see all track reports are there delivered
তারপর একটা দেখাবো
দেখে দেখো একবার
Well, in that case, please serve the state and come back.
yes
I will start I will start
the consideration of the representation state will
that
not
is
serve.
Since affidavit of service. Since there has been a change of learned counsels in the state panel, the petitioners are directed to serve the office of the learned government leader afresh and file affidavit of service on the agenda date. Paragraph, let the matter appear. It's a short matter. I think.
my lord
Let the matter appear under the same heading on 25th January.
Yes, unauthorized construction of Noinjudi. The representation will be considered.
deep apply 25th January এই নামটা
Next.
May it please your lordship. No, my lord, in this matter, I am for the petitioner. The matter was heard earlier, and my lord,
Affidavits are exchanged.
yes, affidavit is exchanged. But a short point of law involved.
very short point.
I am for the KMD.
Well, the KMD is the party, main party is the KMD.
One.
State is also there. Malad, I am also my. Well, the point is short, Malad, and I. Malad, Mr. Bashu is sitting.
For the petition.
What? Petition? Yes, yes. We are, can you allow him to proceed? I'm taking.
No, before Lordships, Malad, open the pleadings, Malad. May I just indicate, Malad, what is the issue involved in the case and what is the point I am going to address? Now, Malad, my land is, Malad, Malad, I am, Malad. The petitioners are all senior citizens. Malad, they are the owner of a large chunk of land on which, Malad, a flyover has been built. Malad, the land was taken, Malad, without there being any steps as that at that point of time in acquisition or by acquisition. Now, Malad, in circumstances, we wrote series of letters, including Malad, the state government and also the state KMDA. And Malad, as there was no output, Malad, ultimately outcome, we Malad filed a writ petition. Now, Malad, writ petition was hard before this honorable bench. And the first writ petition was disposed of with a direction, Malad, to take steps for acquisition of the property. And Malad, after this order was passed, Malad, they were silent. We Malad issued contempt notice. That see, we are all senior citizen for last 5 years, Malad, we are out of our land. No legal steps have been taken. What have you done? Well, when, Malad, on the basis of this contempt petition, what they did, Malad, they gave us order for, Malad, by purchase of the property. So, Malad, the purchase, Malad, there were series of dispute in respect of that, and if it goes by purchase, we are going to lose. One of the point involved today before your lordship is that now if, Malad, a land has to be taken, Malad, that has to be taken by way of acquisition. And purchase, Malad, cannot be go on the basis of unilateral way. That is the point. And we are also covered by the division bench of this honorable court's judgment, which clearly states the direct purchase policy will not do. You have to take steps for acquisition and you have to do acquisition of this property. So this is basically, and Malad, this is the campus of this writ petition. Now, Malad, may I? And Malad, the rain compensation. The acquisition is done, obviously, acquisition is done under new act, it has to be acquisition. But the rain compensation for this period, prolonged period.
Direct purchase.
No, we are not. We are not. Because Malad, there are Malad, several question arrows. Malad, see, under new act, we are supposed to get Malad 100% solution. Now, if by direct purchase, they are offering 1.50. And then, Malad, there is also another issue. The issue is, Malad, the situation is that some land, they have not acquisition. But these lands are coming just underneath of the subway. So, that portion of the property, we cannot also use. And according to the new act, we are also supposed to get compensation for that. Also in the old act. Well, may allow my signature.
The point is in the short campus. Justice Standard, my lord, if you Dr. Kindly come on page 39 of your lordship brief.
Page 39.
39.
Yes.
If you lordship kindly read this order, everything will be clear and I did not make any further submission on this aspect.
This is the same petition.
No, this is unallowed notification where the court says that your acquisition fails.
The same petition.
Yes. There is no acquisition at all. In 42nd paragraph, the fact remains that no proceeding was ever initiated.
80.
You are also enjoyed. You have to carve for it.
Yes.
So today's situation is there was no acquisition, but my land has been taken, utilized everything, and one part is not acquired, but I cannot utilize that even today. So entire land is now today is belongs to me, but utilized. What is the consequence? There is no other alternative but to go under 2013 Act. Now they came with a proposal that direct purchase policy. This purchase policy has to be, my lord, on compromise. I have to accept because this land acquisition proceeding is a compulsory sale. Sell, you have to sell it. But direct purchase policy is purchase. If I'm not willing, you cannot force me.
Cannot be done unilaterally.
Cannot be forced. This is the situation. Now, my lord, another thing, this is the first part. Second part is possession was taken in 1980. So, my lord, till today, I repeat, till today, I am entitled to penal rent compensation. I repeat, penal rent compensation, not only rent compensation. When you are acquiring a property, requisitioning a property, I am entitled to rent compensation because you are legally requisitioning a property. But if you are not exercising your power under the statute and grab my property, I am entitled to a penal rent compensation.
That has also been decided in the earlier petition.
Now, my lord, wait.
Only the quantum needs to be decided.
That is the thing. Now, my lord, kindly come to 240. I cannot worry. I get factor that
240.
240.
Yes.
My lord, I think my lord's conscience will be soft. In continuation of the earlier memo number such and such, it is such and in pursuance of your letter date such, and to comply the order of this court, you are hereby requested again to convey your consent for acquiring land value as per the direct policy purchase policy for the land area comprised into CS plot number such and such area as 5 crores 67 lakh, where it is just below the, my lord, the flyover of Lake Gardens. My lord has physical access to the judicial notice, my lord can take. Can it be this amount? And quantum is 0.365 acres. And now, my lord, kindly come to Department of Inner Government of West Bengal approve the additional 50% of the above mentioned land value, which amount to be such and such. Because if I go to 2013 Act, I will get 100% solicium apart from other things. Now, so far as rent compensation, they have also ascertained. My lord, kindly কত টাকা দেবে বলেছিল? হ্যাঁ, now kindly once the guideline 213 ওটা বার করে কত বলেছিল 213, if you lordship kindly come, this is the formula laid down for assessment of division of rent in respect of private premises hired for public purpose. This is the policy. I say this policy may not be attractive because these are all legal acquirement of property, not grabbing. If you are grabbing the property, penal consequence will follow. So that they are also liable to quantify. 240, But kindly come to, yes. Kindly come to page 204. Even I considered that up to 2008, then also, according to their assessment of rent compensation, with reference to the above, you are hereby requested to appear suggestions 12 to receive rent compensation amounting to rupees 76,000 of 0.6656 acre at Lake Gardens, taken possession in 1980. From 1980 to 2018. So this is the quantum, my lord. I said I started with this, my lord, conscience will be shocked. Now today we are losing the property, we are not in possession of 45 years. These are the two things, my lord, we have to canvass before, my lord. Kindly, there is an unreported judgment also annexed here. 221, if your lordship kindly see.
Affidavits have been exchanged?
Yes, yes. Everything is ready.
221.
221 it starts. Kindly come to 225. Kindly come to 223 first. As such, for such unauthorized occupation, here it is unauthorized occupation of the petitioner's land, the state respondent is liable to pay damages, which will be not less than 10 times of the letting value of the said land of the petitioner. 10 times. On this, my lord, this is the finding of the court, and accordingly, this judgment was delivered. It is further made clear that the land acquisition collector is also required to assess the damages for wrongful use and occupation of the petitioner's premises with effect from first, in that case, 1st April 1997, till the date of delivery of possession. In that case, possession was delivered, returned back at a penal rate. Here it is not possible. So at least our prayer is, till such time you are issuing notification under 2013 Act, I am entitled to the penal rent compensation, which according to the court, your lordship's court, 10 times of the reasonable letting back. Now, my lord. First of all, I will show to your lordship, my lord, though this is judgment of the Honorable Single Judge, your lordship, coordinate bench, Supreme Court also says like this, is reported in 2011, 11 SCC. What the said? Reported in 2011, 11 Supreme Court cases 648. Copy nahi to? Last. Yes. Paragraph 13 to 15. Though the respondents are not entitled to interest under section 28 of the Act from a date prior to the date of primary notification, they are entitled to damages for wrongful use and damages of the land from the date of possession till the date of notification of section 4.1. This is my claim also before mine. The case was cited, my lord, then 15. It is clear that even if the landowner may not be entitled to interest from the date of possession, but only from the date of preliminary notification, he will be entitled to compensation for wrongful use and occupation from the date of actual dispossession till the date of notification under section 4. Here notification has not been issued up till now. In this case, there is already a clear finding that the loss of income per year was 94,500 from the acquired land. Therefore, instead of litigating the parties for a further inquiry in regard to damages for the wrongful use and occupation from the date of possession, dispossession to the date of preliminary notification, we proceed to determine, court has determined that. Here also, I will request your lordship, keeping in your lordship judicial mind, what is the property, what is the quantum of property, and 1980 till 2020-24. If my lord decide a reasonable compensation, then I will proceed. I'm not getting anything. And up till now, there is no notification under the new act. So, my lord, they should return. Now, what can be done? Now, my lord, division bench judgment of your lordship's court, what is the judgment? But kindly come to, this is reported in, not reported, 2022 SCC online 4199. Kindly come to paragraph 3. The court records the read petitioner respondent's case to have arisen out of the grievance that the state authorities acquired and utilized the plot of land owned by them for the purpose of construction of a road, similar here. But no compensation for the same has been granted to the petitioner. A notification is referred to. The notification court records that in view of the said notification, the read petitioner respondents are agreeable to proposal of the state for direct purchase of the land in terms of the said notification. Notification then, my lord, quoted. Next page. Then, my lord, kindly come to, I will not travel also entirety, kindly come to paragraph 16.
Yes, 16.
However, the purpose for which the said proceeding was started, that is construction of Chandpara Thagurgram road, was materialized and construction of road was completed. In doing so, certain amount of land comprised with the above named 3 mojas has also been utilized. Here also same thing. I want to show to you the facts. Then can we come to paragraph 58?
58?
Yes. The other point, what mentioning is that though the appellant has claimed to have determined the compensation in accordance with the provision of 2013 Act, from the document submitted on behalf of the respondent's petitioner being annexed with his affidavit of revision, it could be gathered that the calculation and determination of compensation was done in awarding under section provision under section 11 of the repealed Act. So there is no award. Illegality of state action is absolutely manifest, which cannot sustain in the eye of law. So, if you see eliminate, you will find we are on the same footing like this matter. Award no notification. Here also award pass set aside because this is under the old Act. Now the direction of the court. 59. In the facts and circumstances aforesaid, we dispose of the appeal and the connected application with the following direction. The order under appeal set aside, we declare that the award published set as honest. The acquisition proceeding have lapsed by reason of non-publication of the award within a year from the date of publication of the award, because there is no award in our case. The state is not in a position to return the land to the owner since the same was utilized for construction of public road. Then, consequently, the state shall start fresh acquisition proceeding, which will necessarily have to be under the provisions of 2013 Act, as there is no other statute under which acquisition proceedings can be initiated. Such acquisition proceedings shall be initiated and completed, and the compensation determined under the provisions of 2013 Act shall be paid to the respondent petitioner within 4 months of the date of communication of this order to the concerned land acquisition collector. So, my lord, according to my humble reading of this judgment, is squarely applicable to the facts of this case. There, my lord, acquisition proceeding initiated but culminated into non-est. Here there is no proceeding. So the alternative is this: you cannot thrust on me a direct purchase policy if I don't agree to it. So, my lord, I will be praying, my lord, similar order which passed by the Honorable Division Bench in this case also, and also I will be praying, my lord, directing the authorities to give me rent compensation till 1980 till notice under the 13 Act is issued. And that should be a penal. That's
Here the state is the principal answering respondent. We are of course the requiring authority. My lord, I may make submission, my lord. I do not know whether the state will make.
may I, please, my case. Well, we have not filed, we have not used our affidavit. State has filed its affidavit and they have filed reply thereto. Well, here, although fact remains, the land was acquired in connection with the LA case in 1979-80.
I am, my lord, opposing to his prayer, not acquired.
Illegally taken away. Acquired has a legal sense.
There was no
Let me submit.
Acquired কি করে?
Possession was taken, according to him, possession was taken in 1980. But when the petitioner for the first time came, approached this honorable court in 2018. Yes, we are, if we are, there also, some fault lies with them also. Be that as it may, my lord, that writ petition was heard and order was passed. That order, since we have not appealed against, that is equally binding on the state authorities as also the petition. Let us come to the order, my lord, once again, my lord, at page 39. He is raising claim over an area of 41 decimals.
Yes.
If your lordship kindly takes the first page of the, at page 39. Indubitably, the land of the petitioner measuring more or less 0.365, not 0.41. More or less cannot go to 365 cannot go to 41. Be that as
Even if we take it as 365.
the point regarding why I am showing this recording, my lord, this was not disputed by the petitioner. Why this has? Because the KMDA, it facts remain, my lord, the KMD in long back in 2004 made a proposal. There was, my lord, tentatively 0.365 for that proposal was made. My lord, for some reason or other, although the KMDA sent proposal in 2004, that was not materialized. Ultimately, it's an admitted fact that acquisition was not done. But some portion of the land was utilized for the purpose of construction of the road. Well, this, if your lordship kindly, now my learned friend is harping on some other thing which is not in the order, and they also cannot go beyond this order. My lord, may I read from page 40, last paragraph. On the basis of an undisputed fact that there is no doubt in my mind that an individual has been deprived of his property without recourse to law, and to undone such unconstitutional act, the property is required to be reverted back to the owner. But this court cannot overlook the fact that such property was required and utilized for larger public purposes and for construction of a connector facilitating the citizenry of the city to have smooth and more convenient journey from different parts of the city. The court finds that possession of the land of the petitioner cannot be given to him, as the situation which is prevalent at present renders it irreversible. Since the KMDA as requisitioning body have been informed to make a fresh proposal, this court permits the KMDA to make a fresh proposal within 4 weeks from the date, strictly in terms of the extant rules, guidelines, act applicable in this regard. My lord, here why this recording was, my lord? Initially, we made proposal in 2004. Thereafter, once again, the state had directed us to make a fresh proposal that has been taken note of in this. My lord, I will be emphasizing on this. Since the KMDA as requisitioning body have been informed to make a fresh proposal, this court permits the KMDA to make a fresh proposal within 4 weeks from the date strictly in terms of the extant rules. Here, Lordship, kindly, my lord, extant rules, guidelines, or act applicable in this regard. Lordship, kindly, I will be emphasizing on this line. Then, my lord, this is the my lord, obligation of the KMDA to make a fresh proposal. The state is directed to take recourse to acquisition of the property as per the extant guidelines. As per the extant guidelines, and it goes without saying that the entire exercise shall be completed within 8 weeks from the date of the receipt of the fresh proposal from the KMD. Then, my lord, the other part contains, my lord, though this court finds that this direction has been passed to mitigate the situation and to secure the ends of justice, yet this court cannot brush aside that the petitioner has been deprived of his property without the payment of a single further. The land acquisition collector, South 24 Parganas, is directed to determine the rent compensation from the date of possession till the date of an acquisition of right title interest by the state, and shall pay the same to the petitioner along with an interest of 6% per annum. The said land acquisition collector shall complete the entire exercise within 8 weeks from the date of communication of this order.
This order has not been complied with.
My lord, this has been complied with. My lord, this order contains two parts. KMDA to make a fresh proposal to the acquiring authority in terms of, strictly in terms of the extant rules, guidelines, or act. It is not specified. The order was passed, my lord, in 2018, when 2013 Act came into force. But the court, having regard to the situation, the facts of this case, my lord, was pleased to record these as per the extant rules, guidelines, or act. And then the state was directed to complete the entire exercise as per extant guidelines, not as per the provisions of 2013 Act or so, my lord, the obligation on the KMDA was to make a fresh proposal. My lord, we have made a proposal. Upon inquiry, upon joint inspection, we found, my lord, sorry, one line, my lord, I must show to your lordship. Lordship, kindly. The quantum of here in this order, the land which has been utilized or used by the KMD, my lord, for the purpose of making fresh proposal, we had to make a joint inspection once again. And on inspection, my lord, we found that not 0.365 acre has been utilized, but 0.31 acre has been, that is 31 decimal has been acquired.
Inspection was in presence of the petitioner?
It was, this inspection was done, my lord, with the state authorities, with the state authorities.
And the petitioner's back.
Yes, that with the state authorities. I find joint inspection was made, and it was found, my lord, that only 31 decimal, that is 0.31 acres, was utilized for the purpose of constructing the road from which is owned by the petitioner. So proposal was made to the acquiring authority, to the state authorities in terms of the order passed by this honorable court. This fresh proposal was, my lord, made for 0.31 acres of land, and it was submitted to the state authorities on 7th September 2018.
Part of your affidavit.
My lord, that has been, my lord, annexed in the affidavit filed by the state. It would be convenient, my lord, had it been placed by the learned council. Lordship, kindly take up the affidavit in opposition of the state. My lord, got it. It is affirmed on 24th September 2020.
Has the state filed the affidavit?
Yes, I think so, my lord. They have also replied to that.
I'll just find it. Affidavit in opposition state.
From the 24th September
Yes,
2020.
yes. Whether that was a copy was provided to me, my lord. That is why, my lord.
State respondents, 6-2.
আমার কবিতা দিলে আমি বলবো কোথেকে? এই না দাও না তোমার কবিতা। ওইটা তো
Yes.
Lordship kindly takes up page 10 of that affidavit. 10. 10. This is the proposal we have made to the state authorities in terms of the order passed by this honorable court in the earlier writ petition of the petition. My lord, got it. The second paragraph, Lordship will find that regarding the joint survey, which I have right now submitted.
Yes.
And next page, Lordship will find the penultimate paragraph. In this connection, it is to be noted that the KMDA had already issued an account pay check 92,76,346 in 2011 in favor of collector as 50% of the land acquisition cost earlier, which is lying with the collector. My lord knows that while at the time of proposal, the requiring authority has to pay the 50% of the cost of acquisition that was submitted and was lying with the state authorities, that was mentioned in that very letter. And then the LA collector, my lord, prepared estimate and informed the authority, my lord, the KMDA requiring authority, that is the KMDA, and the KMDA furnished the said amount to the land acquisition, the state authority, that is the collector, on 20th February 2020. If your lordship kindly comes to the averment made, if your lordship kindly takes up the amendment made, just amendment made in the opposition.
Yes.
After this, my lord, this is stated in paragraph 3b, and 3c says that upon the order of the Honorable Court, the rent compensation was calculated to 76,100 for the period so and so, along with the interest at the rate of 6% of the total amount. The writ petitioner were requested to receive the same amount, but no response from the writ petition. Then it says, my lord, that in absence of any rule, the acquisition of land under the new act cannot be applied for new acquisition cases in West Bengal. Instead, as an alternative method, the state government adopted a policy of direct purchase by notification number so and so of 25th February 2016. Since, my lord, there is no rules, 2013 Act could not be applied. In such a situation, government has adopted a, my lord, policy which is annexed, my lord, at page 12.
This cannot be unilateral. It has to be on consent.
Well, what is stated, my lord, as a matter of fact, my lord, I am placing it. Then, my lord, he says that an amount of rupees 5 crores 67 lakhs 823 was estimated and approved by the Department of Land and Land Reforms, which was offered to the petitioners, inviting consent to proceed in that regard. The writ petitioner were also offered an additional amount of rupees 2 crore 50 lakhs 33,911 as vetted by the so and so if the registration so and so. So they were, my lord, calculation was done and offer was made as per the policy of the government, my lord, which they did not respond to. And the calculation, lordship will find that page 17, 19 is the land value calculated, and we have duly furnished that amount with the state authorities. So far, our obligation is concerned, my lord, we have discharged our obligation. Lordship will find from page 20 onwards, several letters were addressed to the petitioners requesting them to accept that that calculation was done on the basis of that policy, particularly that is at page 14, the clause 11 of C11.
This is the direct purchase policy.
Direct purchase policy.
This is not accepted by the petitioner.
But here, my lord, my humble submission is, my role is very limited, my lord, having regard to this. First of all, my lord, the petitioner is claiming in respect of 0.41 acre, which they cannot. Even if assuming they are the owners of 41. After this order was passed.
They are claiming in respect of 0.365, I think.
No, they are claiming they have obtained, my lord, valuation in respect of 0.41 acres and claiming that amount. Claiming that amount, which they cannot, Because in view of acceptance of that very order, from that order, my lord, neither parties can go beyond. He is claiming value for 0.41 acres.
So I think the petitioner will claim 0.365 and not 441. In terms of the earlier order, I think you have to limit your claim to confine your claim to 0.365.
First of all, there is more or less, and secondly, if your lordship apply to the law, lordship will find even if they have not acquired that part, but I cannot duplicate it. So the compulsory acquisition has to be into the old act also, 1894 act, and these are here also.
Yes.
Section is there. I will place one.
Secondly, my lord, that order in the order passed by my Lord Justice Tandon, had it been the intention of the Honorable Court, it could have been mentioned the provisions of the Act. The extant guidelines or Act would not have been mentioned, subject to correction by my Lord.
But the direction
Because
before
court was
acquisition-
aware, the Honorable Court was aware of the fact that 2013 Act, though there is an Act, but in absence of rule, the provisions cannot be given.
The specific instruction order is for to take recourse to acquisition of the property, not direct purchase. Please come to that relevant paragraph.
No.
Page 41,
Yes, 41,
third paragraph.
third paragraph. The state is directed to take recourse to acquisition of the property.
Yes. So no direct
As
purchase, it's only acquisition.
Ancillary.
Acquisition, my lord.
Acquisition as per extant guidelines. So not
Extant.
that. So that
And
is
law,
different.
law also there. Law also there.
Extant guidelines. If we take, my lord, the third paragraph.
Yes, yes.
Acquisition, whether subject to correction, of course, my lord. Certainly, my lord, when the Honorable Court was pleased to take note of the extant rules, guidelines, or Act, because Court was aware of the situation that there is no rule framed.
Presumption.
Not presumption, it was the submission in course of.
Very well, but did not direct purchase policy. Today, you have taken, my lord, the government valuation. 10 crores is the valuation. Plus 10 crores is solicium. Give me 20 crores, get it direct purchase policy.
That is not the daga. And you cannot claim for 41 decimal.
And law
Your-
permits me, you have to acquire that part also.
That part for that, this is not the prayer in the writ petition, which we have utilized. That was the order. KMDA
I
utilized
fail to
without.
understand, my lord. If
No,
I
no.
am getting the benefit of the law, I have to plead the law. That we have not taught.
Have you played?
Not necessary.
Not
And I
necessary,
say
everything.
I say from their own
Let it- let-
admission, I'm not going to that part. Kindly come to that admission. Page 2 of the affidavit of state. Page 7.
আমায় শেষ করতে দিচ্ছে না।
আমি রাজি তো ডাইরেক্ট পলিসিস করেছে। Paragraph 6.
Your only prayer is compliance of the earlier order.
Compliance of the earlier
That
order.
includes both. Acquisition,
And when
Lordship, kindly have a look the earlier prayer.
acquisition
Let him.
comprising of the unacquired portion which I cannot utilize.
No, that
Law is
cannot be
there.
presumed. Everything cannot be
It was
presumed.
not stated before the earlier.
Not necessary, but are subject to correction, but not necessary because if you want to acquire it, you have to acquire under a law. If the law suggests that unacquired portion the owner cannot utilize, then you have to acquire it. That's the law. And kindly see their admission. Page 7. Paragraph 6. May I read for your lordship? In this connection, KMD also stated that a joint survey was conducted from their own end and it was revealed from the said report that actually 0.31 acre of land out of 0.41 acre.
That is his claim.
Can I read that along with section 28? I did not plead. That is the outcome of the law.
When there is a specific order
Subsection 3.
to the extent used and utilized by the authority without acquisition. So that
This
was
should be
directed to
redundant. So what I will do with this land which is
that
left out?
that law has been made
Make it
provision
clear. Yes, that I'm showing to my lord.
that in this proceeding you cannot. Everything you cannot bring in.
Well, kindly once we look to read 23, once look to it. What the market value on a subsection 1?
2013 Act.
2013 Act. It is also in the 1894 Act also. Explanation. Explanation. While determining the market.
In the earlier order, it was not specified.
Kindly come to 28.
It was never mentioned that that acquisition has to be made applying the provision of 2013 Act.
And third. Third and fourth, sorry. Second and fourth. Affecting injury to his other property, movable or removable. It is not fourth provision. Fourth explanation, I should say. This was also in 1894 Act.
At the time of taking possession,
Yes.
by reason of acquisition, injuriously
Yes.
affecting his other
Injury, I
property.
cannot do anything. The flyover is over my land. So what I will do, the rest of my property. And your lordship can recall, your lordship has dealt with this matter many times. 1894 Act also has a similar provision.
Yes, Mr.
So, my lord, these two cannot be, my lord, the petitioner is not entitled to the relief. So for the quantum of land, he cannot claim more than 0.36. But in fact, my lord, on his inspection, what we found, that only 31 decimal land was utilized. So we have made proposal for 31 because it was the order, the extent of land used and utilized by KMDA without acquisition. So
the inspection was beyond knowledge of the petitioner cannot be relied upon. The demarcation has to be in presence of the petitioner.
no, it is not in dispute. It is not disputed by the petitioner that no.
It is disputed.
No, what they are taking, my lord, that rest of the portion is lying in such a situation which cannot be utilized otherwise.
Portion beyond 0.365.
0.31.
That is your case.
Our case.
And that is also unilateral inspection without the petitioner.
I do not find.
The petitioner is not bound to go by it. Accept it.
So they should limit their to the extent used and utilized.
That is according to the order 0.365.
0.365.
According to the order.
According to the order. But in fact, on inspection, it was found that no, it was not 0.365, it was 0.31 acres. For that, KMDA made proposal. Now it is up to the state how to comply with this order. The estimate as was prepared by the state, we have furnished the fund with the state authorities. So state authorities also take sufficient, my lord, steps by offering the amount to the petitioner, but they have not accepted that.
I asked Mr. Talukdar whether his property is there, he accepted it. He said, yes, I have accepted, I am.
But now, no, it cannot be, my lord, in terms of the order. It my respectful submission, my lord. From the plain reading of the order passed by.
Offer the present market value.
My lord, I cannot say anything. It is the state.
The requiring body.
I am the requiring body.
Please take necessary instructions. He is the requiring body. He has to pay.
My lord, one thing Lordship will appreciate from the spirit of the order passed by Honorable Justice Tendon. It goes with, my lord, in my respectful submission, my lord took note of the situation. In 2018, the order is passed.
Note of the situation and directed acquisition.
Directed acquisition under which law? No, my lord, may I put question to myself? When there was, my lord, apart from 2013 Act, no other land acquisition act was alive. But my lord did not indicate that you will have to acquire under the 2013 Act.
Is there any other option?
Instead, my lord, with the word act, guidelines and extant rules are mentioned. It goes without saying, my lord, in my respect to submit,
All with
the
regard
code
to
of
acquisition, not direct.
no,
purchase.
the honorable
How
court
come
was
they will prevent this? Framing of rules in their state's hand, they will not do it and compel the petitioner to land orders.
I have passed several directions in several matters for acquisition under 2013 Act.
Yes. They will not frame the rule and take advantage of that wrong.
my
And let the state respond on that. Let the state respond to that.
taking note of the situation, my lord, these words were mentioned because by then the state had framed this policy. Although the honorable court did not mention, neither mention 2013 Act nor mention the policy.
The honorable court mentioned acquisition, which is sufficient.
So what is prevailing since, my lord, 2013 Act could not be given effect to in absence of the rules? The state had in 2018, the state's policy is governing the field. The
May or may not be accepted by the
maybe or may not be accepted. But in terms of that policy, this calculation estimate has been prepared.
no other option.
Whether now the question would be whether that policy, that estimate or calculation made under the provision of this policy can stand or not.
Can it stand? 2013 Act says do something ABCD. By a policy decision, he is overriding that. Which is not to be done has got to be done.
But it is not that. No, the rest of the portion, what my learned senior friend is submitting, that court will take entire thing note of. No, in absence of specific, in absence of specific pleading or prayer, for that he has to, my lord, take up a proceeding.
I say my land has been taken, apply 2013 Act.
No,
whatever may be the consequence.
To the extent used and utilized, that is covered
That is
under
not
that
in the
act.
statute.
That is covered by that order. But the rest portion, which is according to you inconvenient to use, for that you have to take recourse of law. In this,
বন্ধ করে এবার। This is called, that's why we have learned চোরের মায়ের বড় গলা।
আমরা চোর নই।
The state wants some other thing? State wants to make.
Well, kindly make it 100 part and give it twice.
Not necessary. 13 part not necessary. Month of January.
I'm not opposing.
Problem is, my lord, after enough effort, we could get this matter hard today.
You needed no effort at all because earlier matters did not.
Many times troubled, my lord, to
Appearing
get
in
this
the-
matter.
Not at all, Mr. Vasu. Appearing in the monthly list, earlier matters they did not appear, so your turn came.
This time, previously, my learned friend had
At least it was without any effort.
very accepted, but give some precedent so that matter in phrasing Lordship's mind, it can be.
The learned counsels for the petitioners and the KMDA. Paragraph. Learned counsel for the state respondents seeks accommodation. Paragraph. Let the matter appear under the same heading on 31st January. Since I've heard substantial.
31st January.
Oh, that week I will not be here.
31st you will not be here?
That entire week I will not be here.
5th February.
5th February.
Next.
Oh, my lord, I will monthly list.
15th February. It will appear in the supplementary list, no longer in the monthly list.
Oh, then it is all. Great.
Supplementary does it. No. 5th February.
5th February, monthly list not, they can next.
Yes, 5th February is monthly list day. So let it not have 7th February. Let us not fix on
7th February.
Second or second?
7.
Yes,
602.
The matter is otherwise ready for hearing, but I'll be candid before your lordship. I missed the brief today. Can I come back on day after tomorrow, Mala?
Respondents are also not there.
Well, Mr. Chondi Charan was appearing. Affidavits have been exchanged and the matter is otherwise ready for hearing.
Let's wait for here.
My lord.
None appears for the respondents. Paragraph, let the matter appear under the same heading. On 5th February.
5th February will be monthly list, my lord.
Oh, 7th.
7th, my lord. I'm grateful. May I serve them in the meantime for a formal notice?
Oh, yes.
My lord, I shall. I'm grateful, my lord.
Who should do it?
603.
My lord, appearing for the petitioner led by Mr. Hajra, who is suffering illness for his kindly time. Not today, not today.
We are today I'm filing under opposition.
Yes.
Opposition or I am filing to them. The dates of filing under opposition.
Reply filed.
Reply, Maharashtra, we have not served the call today. I am not serving.
We are serving today. Monthly list of February. Affidavit in opposition submitted on behalf of the state respondents is taken on record. Paragraph, affidavit in reply is yet to be filed. Paragraph, let the matter appear under the same heading in the monthly list of February 2020.
Lordship, in this matter, Mr. Shutitya Das is appearing on behalf of the petitioner, and he is engaged before the another court, and the affidavits are already being exchanged, Your Lordship, in this matter.
Who is appearing for the respondent? Sir, Devroy respondents. Is your affidavit in reply?
It's already being filed. It is being exchanged. I'm being informed that.
Opposition has been filed. I do not find the reply. You sought extension of time on the earlier date.
For filing the affidavit in reply. I'm just being informed, Your Lordship.
2020. After that, you have not filed.
So, Your Lordship, kindly fix it on next week, and we will take the step accordingly.
None appears for the respondents. Paragraph, on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 5th February.
Deeply bless you.
605.
Lord, I appear for the KMT.
Petitioner?
Nobody.
The earlier occasion also no one appeared.
In the earlier occasion also none appeared.
Okay, let it be dismissed. Several occasions no one appeared. None appears for the petitioner, no accommodation is sought. Dismiss the report.
Dismissed.
606.
Yes, petitioner?
Yes, ma'am.
You're the petitioner?
Yes, sir. I'm challenging. Yes, ma'am.
Let me fix a date for hearing. Please inform the respondents.
Earlier occasion also.
No one appeared, yes.
No, ma'am. I am challenging the order of the district magistrate.
Please come back on the next date and appoint someone. None appears for the respondents. This paragraph, let the matter appear under the same heading. On 5th February.
5th February.
607.
Now, my lord, this is the case. I have complied on the direction of your lordships. I have served the notice and informal, though in the matter, single bench. There is a provision of filing a paper book. But I submit your lordships, my lord, for the convenience of the court. So many papers are there. I just prepare a consolidated form of paper, type of paper book. Otherwise, very, very difficult to follow. Link to my. এটা কি? Well, kindly but because everything, kindly fix the date so that it can be disposed of. Because it is my headache, my lord. My client is a turban, but I don't have any turban. If something is put on my head, I die.
Affidavits are exchanged.
Affidavits are exchanged, and only this is to be filed. No, yes.
Served a copy to the.
Yes, everything. No problem. Very minor, ঠিক আছে।
There are several private respondents also.
Notice, sir.
So,
Yes, that was our instance, because one of the points which I have taken, of course, I was faculty corpus. Initially, going to the order, I thought that, well, the order which was passed by your lordship's court, not the Jyoti Bhattacharya, as his lordship then was. Jyoti Purnam to Jyoti Bhattacharya. Junior ছিল যে নাম ধরে রাখতাম। Anyway, now my lord, so my lord, I thought, my lord, that, well, in my absence, order is passed. And the persons at whose instance order is passed, naturally their presence is needed. But after going through the papers thoroughly, I found it's not that their presence is must, but since I mean, the party have served the notice, if they so desire, once appeared, my lord. Sometimes they are appearing, sometimes disappearing, putting me in trouble. আরে ভাই এসো আর মামলাটা করে দাও না ভাই, হারিজিতে অন্য কথা নাই লাজ।
I'll fix a date for hearing.
My lord,
please inform the NHAI. Mr. Das is. Oh, you're there.
ওই তো এসে গেছে।
Let there be a date for hearing.
ওই দিন আর ওই দিন পালাবি না, ধুন্দুমার কাণ্ড বাঁধিয়ে দেবো। My lord, fix হচ্ছে ডেটটা।
Informal paper book submitted on behalf of the petitioner is taken on record. Paragraph, Learned Counsel for the state respondents seeks accommodation. Paragraph, that the matter appear under the same heading on 31st January.
31st January. I don't mind, my lord, unless 31st January. Is it a Monday? দেখো তো ভাই। Wednesday. No problem, I'll cut that. Sorry. Anyway, well, I'm sorry for your trouble, my lord. I'm doing. I may leave, my lord. My lord, one injustice I'm paying, my lord. At top, my lord. Otherwise, again, they'll live.
2019 matter will appear fairly at the top. Let us see.
Otherwise,
cannot be fixed at the top.
no, I don't know. Otherwise, again, I'll come and disturb your lordship. I'm a very bad man.
Please come back, let us.
As your lordship, my lord. Liberty to mention implied. I come back.
Next slide.
608. 608.
I appear for the petitioner, my lord. We have, my lord, last occasion given a notice to, my lord, government pleader. Affidavits have not been exchanged, because the matter pertains to 2019, my lord.
Lord, I am for the WBSCTCL. State respondents is.
Opposition.
Yes, Lord. We have received just for but kindly extend time to file filing.
Weeks. And what about the SUVRA?
Well, we have also filed affidavit. Well, kindly can time for 2 weeks.
The file?
No, not yet.
2 weeks.
2 weeks.
Other councils, huh?
Not if required.
Extension of time to file affidavits in opposition. Paragraph, affidavits in opposition be filed within 2 weeks from date. Stop affidavit in reply, comma, if any comma be filed within a week thereafter. Monthly list of February. Paragraph, let the matter appear under the same heading in the monthly list of February 24. Show the affidavit of service. Yes, please.
Well,
Affidavits
but similar matter 9 and 11,
9.
same matter, similar matter, you will also pass this order. Kindly see, compensation,
It's appearing for the respondents.
compensation, my lord, of March 2023, my lord, pass the order, and 2 matters is
9 and 11, same matter.
Why affidavits?
My lord,
Why would affidavits?
affidavits.
There was a direction for affidavits.
No. We have not filed, my lord. They have not filed opposition. State has not filed opposition in spite of direction.
That's affidavit. Yes, there is your affidavit.
Well, we will also kindly pass that order.
Want to file affidavit?
But totally my regards 2 weeks time like
2 weeks.
Did you serve the private?
Yes, my lord. Compensation only at your lordship. Kindly see your lordship's order. Earlier occasion.
I've seen that. Where is the service on the private respondent?
Well, evidence of service is there.
It is only on the state. It is not served. Only bag opened.
Well, my direction is your lordship kindly direct the district magistrate to consider my representation as your.
Serve the private respondent, sir.
Then my lord kindly give you.
Please serve. This becomes a ground for appeal otherwise.
It has not been served. Yeah.
Item bag opened. The last track report. That was in 2019.
Only sent, not served. No. My lord, need not. Bag open.
It has to be served. Since service upon the private respondent is not complete, let the matter stand over till 29 January, short matter. 29 January.
Start this corner. यार बोलो पहुंचा ही नहीं फिर बाहर कुछ तो बेटा
610.
But I am for the petitioner, my lord. But there was a direction to file affidavit.
Keep job the people. I'm praying.
611 you said same.
Yes, same.
I have to check
9 and 11.
9 and 11 I have to check the service. Please wait for a minute. This is 10.
Yes, my lord.
You have
Affidavits have been exchanged, my lord. Yes, my lord.
My lord, I'm led by Mr. Ghazi Farooq Hussain. He left the court right now. Kindly, my lord, not today.
Yes, my lord.
Today.
I have served through the register.
You are appearing for the state?
No, my lord, petition, respondent.
Which
No,
respondent?
private respondent name.
আমাদের আছে আমি জানিও না
Huh?
my lord kindly pass it over
No,
for the
no
day, my
private
lord.
respondent is there, my lord. Only state respondents. Only the state respondents, my lord.
So Mr. Day is appearing for
Yes,
the state.
my lord. My lord, matter relating to my lord regarding compensation, my lord. The state.
Let there be a date because Mr. Day is also not there. Affidavit in reply submitted on behalf of the petitioner is taken on record. Paragraph none appears for the respondents. Paragraph let the matter appear under the same heading on 7th February.
Much obliged.
Yes, next.
611.
Many see you lordship private respondent received it or not.
Anyone appeared for the private respondents? It's the private respondent. Oh, the same person.
Same person.
Rajan. No affidavit of service.
Is not.
There is no affidavit of service. 5. Service.
No.
You are appearing for the state?
Yes.
No. Serve and come.
I'll submit.
Since service upon the private respondent is not complete, let the matter stand over till 29th, I said. 29th January.
Well, I'm paying leave.
Next.
612.
My lord, being led by Mr. Shamik Chatterjee, I beg to appear for the petitioner.
Respondents?
My lord, I'm praying, my lord, kindly fixes the matter at any time after 16th if it is convenient to my lord.
It's appearing for the respondents.
My lord, as per the last order, Mr. Jahar Lal Desh and Mr. Mainak.
Affidavits are exchanged.
No, my lord, there was a direction for report to be filed by the state. It is still yet to be filed.
The motion is there. A report was called for. None appears for the respondents. The motion is over. Let the matter appear under the heading Group 1 motion on 8th February.
Much obliged, my lord.
Bravo. 613.
I am appealing for the petitioner, my lord. As per my lord, earlier occasions, my lord, verbal order, my lord, I have served the notice upon the learned council for the school. And
For the state.
still, my lord, Jawaharlal De and my lord, Tulsidas Rai, learned.
They are still in the panel, I hope. No?
No.
In the earlier matter also the same thing. You have to serve afresh at the GP's office. Yes?
Copy of the interstate. Only notice.
GP's office because the council has changed.
Yes. My lord,
No longer panel, I think.
no. So only notice will be served.
No.
Copy,
Entire
interstate.
Because a new set of advocates has to appear, isn't it? None appear, affidavit of service. Paragraph none appears for the respondents. Paragraph since there has been a change in the there has been a change of councils in the state panel, comma, the petitioners are directed to serve the office of the learned government pleader afresh and file affidavit of service on the adjourned date. Paragraph
And also notice to the learned council for the school.
for the school.
Yes, school one. Respondent number 5 to 6.
Please serve and come back.
Yes, ma'am.
Paragraph, let the matter appear under the same heading on 21st February.
21st. Grateful.
HON'BLE, edit the order.
21st February.
614.
Yes, you call my church.
614.
None appears for the parties. Let the matter appear under the same heading in the monthly list of February 2024.
615.
Same order.
Six 616.
Lordship, in this matter, I am on behalf of respondent number 5, that is the private respondent. And Lordship, affidavits have been exchanged between us.
Not on record.
Not on record. I am giving the affidavit in opposition, but a petitioner did not appear. But a reply has been served upon me.
Petitioner is not there.
Petitioner is not there. That Lordship, in that event, Lordship,
But the private respondent.
I am on behalf of the private respondent, that is respondent number 5.
Is the state here.
State is also not appearing, Lordship.
Here also they have to serve a fresh notice. Mr. Shengupta and Mr. Buchait were appearing. They are no longer in the panel.
Then I will serve my copy of the opposition. I will serve again.
They have to, some new person has to be appointed first.
Lordship, then I will serve upon the new person, Lordship. I will serve upon the new person.
Person is.
No,
Once the petitioner serves afresh, how do you know the new person? Affidavit in opposition submitted on behalf of the 5th respondent is taken on record. Paragraph none appears for the petitioner. Paragraph since there has been a change of councils, change of learned councils in the state panel, comma, the petitioner is directed to serve the Office of the Learned Government Pleader afresh and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading in the monthly list of February 2024.
And Lordship, from a GP office, I will also be able to collect the name of the new new.
Seems so interested, sir. It is all the responsibility of the petitioner.
Lordship.
Yet the private respondent.
Lordship. Actually, Lordship, this is a long pending matter, and due to pendency of this writ petition, Lordship.
It's filed by the petitioner.
Yes, Lordship.
Interested at all in the matter?
Lordship.
Let's see.
Lordship.
Next month.
617.
But I'm on behalf of the Asansol Durgapur Development Authority.
Petitioner is not there.
Is not there.
None appears for the petitioner. Let the matter appear under the same heading in the monthly list of February 2024. Last matter, our actor deputy.
618.
What are the petitioners? My lord, in earlier, thrice, my lord, your lordship's my lord was pleased to direct me to serve the notice to the, my lord, the state respondent. My lord, after changed circumstances, my lord, the flow of water, my lord, petitioner is agreeing, my lord, to extract the sand from the land.
But
Lord,
who is appearing for the petitioner, for the respondent?
respondent, my lord,
Serve afresh, Mr. Sengupta was appearing.
but my lord, kindly, my lord, engage, my lord, Mr. D, my lord, then my lord, matter will be. No, my lord, he is already retired from this government panel.
Who has, I know. Can the court appoint anyone? The court's choice?
No, but because my lord, the
Not
matter will be hard, my lord, thrice, my lord, your lordship directed the matter, he
Serve
never appeared.
his office.
But he never appeared, my lord.
None appears for the respondents.
Very
Since there has been a change of learned counsels in the state panel, the petitioner is directed to serve the office of the learned government pleader afresh and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 5th February 2024.
This month, my lord, it's an urgent matter, my lord, to be your lordship due to urgent.
29 Jan. 29 Jan. Please serve the GP's office and come back.
Yes, yes, no, but your lordship, my lord, the matter will appear supplementary.
After service, if no one appears, then I can appoint someone, not before that. You have to serve first, isn't it? It will appear in the supplementary list.
My lord, may I have your kind leave to mention, my lord?
This is not the mentioning.
My lord, I can understand, my lord, the predicament is my junior friend mentioned the matter in the morning. Your lordship is under the impression a certified copy is needed in our arbitration proceeding. My lord, the certified copy, provision of certified copy or
Mention tomorrow, I'll consider. Some order has been passed, please find out.
Your lordship, the affidavit reply may be taken on record.
Yes,
I'm filing.
an order has been passed, I could miss the bus.